Hearing Court of Appeals of the State of Michigan is now in session. The Honorable Mark T. Boonstra, the Honorable Annika Ledica, the presiding Honorable Christopher M. Trebilcock. All persons have business here and draw near, give attention and shall be heard. The United States of the United States, Michigan is on report. Please be seated.
Thank you. Good morning, everyone.
I'll say good morning.
Good morning. I know. Good morning, everyone. My name is Christopher Trebilcock. I have the privilege of serving as the presiding judge for today's panel. I'm joined by my colleagues, Judge Ledica and Judge Boonstra. We'd like to welcome you to our second day of case call here for April 26th in Lansing. We are panel number 4. Just a few preliminary comments for everyone. For some of you, this may be your first time in the courtroom. And so I'd like to just go over some ground rules so everybody's on the same page and we have a good day today. We as a bench, we recognize that these cases are very important to both counsel and the litigants behind the cases. And often our decisions are the final word on the dispute or problem which gives rise to the case today. I can assure you that we have taken a lot of time reading your briefs, becoming familiar with the record below, and really working diligently on your cases and had the benefit of your excellent briefing. So we have a very full schedule today, and I want to go over just a few ground rules as we proceed. First, each party is allotted time for oral argument in accordance with the court rules. Second, if there happens to be more than one attorney, it doesn't look like we have that for the first case here. Please let us know at the outset how, if you are dividing your time and how you plan on dividing it. Third, appellant, before you start your oral argument and as others come up, please let us know if you wish to preserve time for rebuttal and we'll try to help keep track of that for you. The fourth and final rule that we have is that if any of these cases involve children or sexual assault or other sensitive topics, please do not use the parties' names or the children's names. Instead, refer to them by initials or other identifiers. This is a recorded public hearing, and it will be posted on YouTube for the world to see later today or tomorrow. So please keep that in mind. My last comment to everyone is based on my over 23 years of practice and my time here on the bench. And my advice is this. Again, we are very familiar with the relevant facts in the case law. There's some of this I wish I knew when I was down where you guys were than I was. But really hone in on the salient legal points or key facts and make sure that we're aware of them. And if we're asking questions, it's not just to ask questions, it's because it really matters and could be outcome determinative. So please focus your time on that. And with that, we'll call our first case. It's item number 16, case number 376607, People v. Miguel Angel Pozas Silva. I'd ask appellant, please state your name for the record, and appellee, please state your name for the record. Counsel.
Yeah, Jerry Scroton-Boer.
Thank you.
And thank you, Your Honor. Jonathan Foreman, Office of the Public Defender of Ingham County. I would like to reserve some time for rebuttal today as well.
Yeah.
So thank you. May it please the court. Jonathan Foreman with the Ingham County Office of the Public Defender. I represent Miguel Pozo Silva here today, and I'm requesting that this court reverse the order of the lower court and determine that the kidnapping charge in this matter should be quashed. I don't intend to take too much time today because ultimately this is an application of facts to a pretty straightforward legal question, I think. It's just a determination of how this court determines the facts apply to that question. But I want to focus on a couple of key points. First, I know there's been some talk about the statutory interpretation and the
What does restraint mean?
What was that?
What is restraint?
Restraint means, so restraint is defined in the statute. And restraint means it's either a restriction of a person's movements or it's a confinement of the person. And I don't think there's any real argument here that that the complaining witness was confined, but there is kind of a dispute as to whether his movements were restricted. The dictionary definition of restrict would be it's not defined in the statute, but it would have a dictionary definition of depriving of freedom or movement of action. So if the complaining witness's movement, his ability to move was restricted, then we would have restraint here. But I don't think we have that. And I think the preliminary examination testimony shows that we don't have that. And that's regardless of how this court interprets the statutory interpretation question, the rule of last
When we
antecedent
look at
question.
restraint, are we to examine it from the totality of the apartment? Is it the bedroom? What is the key? What would you say is our key point of analysis?
So the lower court here bound over based on the bedroom. I think that there's some argument from the people that it is the apartment. I don't think that can be the case because the complaining witness voluntarily, willingly entered the apartment. And from Laporta, which is a published opinion of this court, consent provides a complete defense to the charge of kidnapping.
But can't consent be withdrawn? You may voluntarily go in someplace, but then that, circumstances change. And just because I voluntarily went in, if somebody locks me in, that doesn't mean I consented to be locked in.
Of course, consent can be withdrawn, but there's no testimony here to support that consent was withdrawn here. There was testimony at the preliminary examination that he never asked to leave, that
Does he have to do that?
I would think so, because otherwise a person's subjective, secretly held beliefs could be determined to withdraw consent. And I think if you look at that in other contexts, people aren't obligated to read someone's mind. If someone voluntarily enters your home and then later feels that they want to leave, even though you've done nothing to prevent them to leave, I think that I don't.
You told him that there's somebody else there.
I don't see how that. I don't believe that shows how that he was not free to leave, and that he was provided the Wi-Fi and electricity that he needed to ultimately contact the person. The facts of this case are that the complaining witness needed electricity to charge his phone, needed Wi-Fi to contact somebody. My client provided that electricity to let him charge his phone, provided that Wi-Fi to let him contact somebody.
Right, he grabbed the phone, he ran into the bathroom and locked himself in and called for help. Right?
Because of his subjective beliefs that he was not free to leave, that he could not leave. But those were unexpressed, right? Those were never told to my client, I want to leave. And then my client in response said, you can't leave, or something to that effect.
What if they're too afraid to say they want to leave?
Where someone has voluntarily entered the home on a promise of Wi-Fi, electricity, and food.
And then been sexually assaulted.
Understanding that point, but where someone has voluntarily entered a home on certain promises, and they have never said, I want to leave, it puts an immense burden on a person who is in my client's position to know that he wants to
So
leave.
counsel, I'm out there starving or, scared or whatever. I said, you know what? Come on in. I've got food. I got Wi-Fi. Come on in. I voluntarily go in and the guy, you don't say anything, but the guy sets a gun on the table and says, you're free to go. You're free to go. Aren't we to look beyond just the verbal statements? We look at the totality of the circumstances. Is that not right?
I don't think we look at the totality of the circumstances. I think that's we look at the statute of the language is whether his movements were restricted or whether he was confined, right? So when in your example where there is a gun, there's a credible threat of harm there. And that's what the court has said in the unlawful imprisonment context, where non-physical restraint can only come about by a credible threat of harm. There are certainly no credible threats of harm in this case saying you can't leave or else I'm going to do X, Y, Z to you, right? Does it have to be you can't leave, but I'm going to do this, or can it just be conduct that a person objectively or reasonably feels their movement or their ability to leave is restricted? I think at the very least you would have to look at the objective facts, but here the objective facts I don't believe support that he wasn't free to leave. He was provided Wi-Fi, he was provided electricity, he was provided the means to orchestrate his supposed escape. And I don't see how looking at the objective facts here that it could be said that a person.
So why isn't he just calling in the bedroom?
Because he subjectively was afraid. Right? If he subjectively felt he could not leave, but he never expressed that, He never expressed that he wanted to leave. So my client was in no position to know that he wanted to leave. And look, we aren't contesting for the purposes of this appeal. We're not contesting the CSC. We're contesting,
Oh, no, I understand that.
right. But what we're arguing is that that added level of the kidnapping needs to be, his movements weren't restricted and he wasn't confined because he never expressed his desire to leave.
Is this complainant, does he have some challenges? Is he a special needs person?
That's not part of the record and I don't believe so.
Well, I mean, that's the feeling that I got from the questioning at the preliminary examination. Those are questions that you would ask a child to qualify them for their competency. But I understand your point. It's not entirely fleshed out.
What about your client? Yeah, go ahead. I'm sorry.
No,
Finish.
that was it.
Go ahead.
Yeah, I don't want to go beyond what's in the record, but there's no issue of competency or mental illness or anything like that with this complaining witness that I'm aware of. I was present for that preliminary examination. I don't believe that's part of this case.
It was just some odd questioning.
I do agree with you there. It was a junior prosecutor with a relatively new judge to the bench, so maybe not the most experienced with
All right,
children
so
witnesses.
maybe that was it. Okay.
What are we to make about you emphasize, oh, he gave food, but it wasn't eaten. He gave Wi-Fi, gave electricity, but what aren't we to consider the other facts? I mean, your statement, even once it was charged and he said, I'm going to call someone, didn't your client say, no, don't call anyone?
He said I think what the record
Several times. I think the record at least more than once said, no, don't call anyone.
He said someone might be looking for you or something to that effect. I think that there are other reasons that one could conclude why someone might not want police involved in their home that aren't related to statutory criminal conduct, state statutory criminal conduct, at least.
So is that sufficient to satisfy the low probable cause standard here to give it to a jury?
I would argue, obviously, and here
I
I'm
know
arguing
your-
no.
I know,
but-
I know your answer is going to be.
Yeah. But I think, well, and I think it's also important to look at what the district court, why the district court bound over. The district court bound over on specifically a restriction of movements from on the polling onto the bed. I don't believe the district court really argued relied on the totality of circumstances, at least based on my remembering of the record here. And the polling to the bed, I think, certainly cannot constitute a restriction of movements because the complaining witness was able to quickly move away from that situation and no longer, and his freedom of movement was never deprived. And so I think that in that circumstance, I would say that the polling to the bed cannot constitute. And I don't believe that the totality of the circumstances argument here can work as well because a person cannot be held responsible, I don't believe, for someone's subjective but secretly held beliefs. If a person does not express, I want to leave.
I
The
think
district court really didn't focus on any kind of physical restraint, did it? It talked about intimidation. It said, I think he was sufficiently intimidated. I guess I'm wondering, how does intimidation fit into restraint?
And I would argue it doesn't. At least not without a credible threat of harm. What the people constantly rely on here is that my client was bigger, he was older, but there was no credible threat of harm that if you leave, I'm going to do this. This court in the unlawful imprisonment context, I get into that in my reply brief, has said that in order for there to be non-physical restraint, which I think is what the people are arguing here as it relates to this idea that he was restrained by the totality of the circumstances. This court has said that non-physical restraint in the unlawful imprisonment context has to be accompanied by a credible threat of harm. It can only be accomplished by a credible threat of harm. And here there was no credible threat of harm. There was no threat of harm at all saying, if you try to leave, I'll do this. It's different to say, I'll be sad if you try to leave. That's different. That might be what someone might consider intimidation, but that's different than I'm going to hurt you. I'm going to kill you. I'm going to hurt your family, something along those lines if you try to leave. And so this court has already determined that in the unlawful imprisonment context. I think it would be a good test to latch on to this kidnapping context as well. The statutes are almost identical. And so if the court is looking at that from the totality of the circumstances context, I think the credible threat of harm test is a good one to apply here. And I think that it would require, and I think that would require a reversal in this case. So unless the court has anything else, I think I've made my point. I think the court understands my points. So I'll leave it there. And thank you so much.
Further questions? Judge Butcher? Just let it go. Okay, thank you. You have
Thank you.
some time for rebuttal.
Thank you.
May it please the court, Jerry Scrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. Let's look at the statute. Person commits kidnapping if he knowingly restrains, intending to commit a CSC contact. Restrain means, as defendant correctly said, restrict movements or confine the person.
So as to interfere with his liberty without that person's consent or legal authority.
That's correct.
I just want to finish the sentence because there's more to it. Go ahead.
Yes, that is correct. Now, what happened here is more than non-physical. Defendant, okay, page 28, grabbed his whole shoulder. No, page 27, 28, put his arm around him. 30, grabbed him on the head and pushed him on the bed. Now, the victim did not like that, so he got up from the bed. And that's the physical aspect, in addition to the totality of the circumstances. Now, I'm a little confused by defendant's argument here. He said, oh yeah, he was confined, but there's no restraint. Well, wait a minute. The definition of restraint includes confined. So I don't understand that. Anyways, his question of his statement that the victim has to say he wants to leave. Well, let's take the obvious example. What if defendant had held out a gun, pointed at him? Well, it was only his subjective feeling. Of course, he's not going to say, I want to leave in that situation. We all know exactly that that's a restraint. Now, defendant is also saying, oh, but there has to be a credible threat of harm. Well, that's nice. I don't see that in the definition. Restraint does not say that. And it even says does not have to exist for any particular length of time. And defendant, in fact, said on page 27, he doesn't want him to contact anyone. I'm asking that the court affirm.
Where do we draw the line? Because you take this to its extreme. Anytime you push someone or put your arm around their shoulder, you can charge them with kidnapping?
No, there has to be one of the 5 situations. Let's see now. Yes, I understand that point. That's really got to me when I looked at it. And where on earth did I put it? One of them is CSC. Okay. Holding for ransom, using as shield or hostage, CSC, taking outside the state, involuntary servitude. Any of those. It has, for kidnapping, it has to be the intent for one of those 5. So if I put my arm around somebody, not intending any of those 5, it's not kidnapping. It's that simple. Just to mention a little point, defendant saying that I'm saying that extradition, taking him out of the state, his reply brief said that that would be kidnapping. Not really. We don't interpret the statute to violate the Constitution. The extradition clause would prevent anything like that whatsoever. But anyways, no, it has to be one of these 5 for kidnapping. And yes, when we deal with CSC, it is very broadly written. The case People versus Willis, about 2018 or so from the Supreme Court. Well, this court had said the CSAM statute, the guy in Willis He paid money to a 16-year-old for sex. Okay, fine. He was charged not with CSC, where the age of consent is 16, but CSAM, which is 18. And if you look at the statute, it actually applied. And this court said that. So then the Supreme Court denied leave and said, well, the Court of Appeals was right. But this is very, very broad because it in effect raises the age of consent. Legislature, you should look at it. Well, maybe they've looked at it, but they sure haven't changed it. So we look at the statutory language, and the language requires some kind of restraint. Maybe not much. Remember, doesn't have to be long. Some kind of restraint. And that happened here. There was a physical restraint in addition to the totality of the circumstances. And I asked the court to affirm.
Anything further, counsel?
It,
No,
so
thank
to
you.
Judge Boonstra's point, well, two things. Is this totally subjective? On these facts, what are the objective indications that this person was restrained?
Okay, in the first place, he was held down. He was pushed down onto the bed. It was for a very small amount of time, but he was. In the second place, the guy saying, you can't go out because people are looking for you and you shouldn't contact anybody. When you add those things together, we have it. If all that we have is he's up there, he pushes him on the bed, doesn't sexually touch him, doesn't do anything, then we sure don't have kidnapping. Oh no. But we have it here. Yes, this is on the edge. That is right.
I thought you said all you need is intent to do CSC.
That's
So if he
correct.
pushes him on the bed, but doesn't commit the CSC, but has the intent, isn't it kidnapping then on your
It
definition?
would be very difficult to prove that. Let's put it that way.
Maybe because most juries would say this isn't kidnapping,
That's correct.
right?
It would be very difficult to prove it if he didn't do anything. Just push him on the bed and then after a while, oh, I'm sorry.
Because it's hard to prove intent.
It's hard to prove intent in that situation. In this situation, it's kind of easy given that he in fact sexually touched him. So once again, I ask the court to affirm. Okay.
Thank you.
Okay.
Thank you, counsel. You have time for rebuttal.
Thank you. I'll be quick. Just a couple of points. First, I want to just focus back on Gerald, which is this court's 2022 opinion in the in the false imprisonment context, where this court said that the exerted force, and when we have non-physical restraint, the exerted force has to involve a credible threat of harm. The false imprisonment statute also does not. It has almost identical language to what we have here. And so if the people are going to say, well, the statute doesn't say it, this court has already interpreted an almost identical statute to require that credible threat of harm. And there is no credible threat of harm in this case. The people have pointed to nothing, and there is nothing in the transcript that would point to a credible threat of harm that would allow for this kind of non-physical restraint argument to succeed.
Do you agree with the prosecution's argument that, there is no length of time and so you had the restraint? If you couple, let's say, take away the verbal, if you have the touching of the buttocks and the grabbing of the shoulder and pushing the kid on the bed, isn't that enough to meet the statutory language?
I disagree, not because of the length of time, but because there has to be the interference with liberty and there has to be a deprivation of the freedom to move. That's what it means to restrict someone's movements. So,
And then he got away, which is what you said earlier, right? Because he got away so quickly?
he was never prevented from moving entirely. So Judge Boonstra, to your point earlier, if you, under the people's argument, if there is a hug and even a consensual hug, and you touch someone and the person who's hugging touches the other person's buttocks, the people would argue that that is kidnapping because there is a restraint of movement in the hug and there is a CSC that was committed, right? And I think that when you look at it in that context, that that's why so as to interfere with liberty does so much work in this statute. Because in order to restrict someone so as to interfere with their liberty, it's not that there's a certain point of time, but you look at Anderson, where there was a full body weight and a weapon used to prevent someone from moving entirely. You look at Smith, where there was a drugging to prevent someone from moving entirely. In this case, the complaining witness was never prevented from moving entirely. He was pushed. Maybe there's a contradiction in the testimony whether he was pushed or pulled to the bed.
Counsel, help me square. It seems to me you're encouraging us to look at the totality of the circumstances as it applies to your client, but we can't look at the totality of the circumstances as it applies to the other side of the equation. That we're to look, there wasn't any deprivation of liberty, because if you look at the full context of everything, it was only a few seconds and that there was charging, and we look at all the factors on that side. Aren't we to look at all the factors on the other side, why there could be considered a restraint or a confinement?
Respectfully, I don't think that's what I'm doing. I think what I'm asking this court to look at is what, the physical restraint that the people are pointing to, the so-called physical restraint that the people are pointing to, was a pulling to the bed where the person was able to immediately move the arm. The complaining witness was able to move my client's arm off of him and get up. And whether that constitutes a restriction of movements so as to interfere with the complaining witness's liberty. That's what I'm asking the court to look at, not the totality of the circumstances, just the very specific action of what occurred in that brief period of time where he was pulled or pushed to the bed and then he was able to immediately get up. And I don't think that constitutes a restriction of movement so as to interfere with the complaining witness's liberty.
We understand your point.
All right.
Anything else?
I just want to say, I don't think I conceded that he was confined. The people seem to say that I said that. I don't believe I said that. But certainly if I slipped and said that, I do not make that concession. I just want to make that point for the record here today.
Understood.
Thank you.
Duly noted. Anything else, Judge Boonstra?
Thank you.
Judge Letica? All right. Thank you, counsel. Thank you for your solid arguments and good briefing. That case will be submitted. Now calling item number 17, People v. Thomas, case number 366840. Counsel for the appellant and appellee. Who do we have here? Only appellant is endorsed for oral argument. And I see two of you. Are you both arguing? Only one?
No, I am not arguing.
Okay. All right. It's an important role.
I certainly appreciate it. Meg Byer for Marquise Thomas.
Thank you.
Thank you for letting me join you from the great state to our south, Ohio.
Oh, this is a bad crowd for that.
It's a nice day to be. It's a nice day to be in Michigan after national championship. I'll say that. I want to focus my argument on where the jury went off the rails here, which was at the instructional stage. So we had from voir dire to opening to direct to cross to closings a case about accident. And then we had the wool pulled out from under Mr. Thomas when the accident instruction was impermissibly not included as a defense to felony murder.
Okay, so I think we all understand that the court gave the accident instruction to second-degree murder, but did not give it as to first-degree murder based on second-degree murder plus the underlying felony.
That's our understanding as well. And on top of, so I think that that's certainly an error.
Right.
And I think that's undisputed by the state at this point as well. There are three, I think, largely undisputed instructional errors, one being substantive about the fact that accident certainly does apply when it's raised to felony murder. That has been the case since 1980 and for good reason.
So if we agree with you on that point, do we have to reach the other issues? Except for save the sentencing on the felon in possession?
I don't think you need to. I think that especially the third and the fourth issue sort of might help the court understand why there was certainly prejudice in this issue as well. So not only was the jury improperly instructed substantively, but there were procedural errors that might have contributed to the harmfulness and the prejudice in this particular instance. So the jury was given an oral instruction as to an element at the end of the trial, at the close of evidence, only as to the fact that it should not apply a defense of accident to the lead charge. And I think that adds, so that's what the jury heard at the close, that what you've heard for this entire trial is inconsistent with a possible defense that's been presented. And you should not only not consider it, but you should also not reach second-degree murder until you've decided the question of felony murder. So we're to assume that the jury followed the instructions of the judge, of the trial court judge, and what he instructed them to do, unlike in Hawthorne, where we had this sort of panoply of particular options. We had a buffet of options as it went to mens rea, so the jury could pick between them. What we had here was only touch felony murder. Do not consider accident in your investigation of that, in your consideration of the facts.
Didn't the jury ask a question about that?
It did indeed. It said, what are we to do with this piece of paper? And in an ex parte substantive communication, the judge said, only consider it when you consider, if you consider second-degree murder. And in the instructions, it said, do not touch second-degree murder until you fail to come to a conclusion or find not guilty on felony murder.
So I think you're right that the prosecution concedes that that instruction should have been given. And I think you'll probably find that maybe we do too. But I think the prosecution's argument then is that the facts here don't support the instruction. So what do you have to say to that?
First of all, I don't think that's for the state to decide. I don't think it's for the trial court to decide. I think it's for the jury to decide. And we see that in Hess and we see that in Hawthorne. That if
So it's certainly true that there are times when, and we affirm or we make decisions that the instruction doesn't apply here because it just doesn't fit the facts. So
I don't think that that's what the judge even said in this particular circumstance. And I think that can be indicated if you take a look at the two possible accident instructions for murder. One's a little bit more robust. And we see that in Judge Trusak's giving of the more robust accident instruction to the second-degree murder charge. So we see that it certainly did apply to the facts as they came out. That this was a possible defense. And I don't think there's any plausible argument that the judge made an interpretation of the facts to say that it didn't apply under these circumstances. So it's an error of law. It's certainly, if we don't get to an error of law, it's an abuse of discretion not to use that particular instruction. And the judge even recognized that accident came out to a sufficient extent that it should be used by the court.
So just to restate it, you're saying the very fact that the judge gave the instruction or said you could use it in one instance if you got there says that there was sufficient evidence for that defense.
I think that it certainly saw, if there's a burden to move forward on bringing forward an instruction, that burden was met. And I think that's certainly illustrated by the judge's interpretation of the accident instruction.
Understood. Any other further questions?
So just so that I'm clear, if we agree with you, do we send it back for a new trial on everything, or?
I think it's reversal on the second issue.
So he's convicted of felon in possession, right?
He is convicted of felon in possession. And
It's not an underlying predicate felony.
correct.
Does that conviction still stand?
I suppose that the testimony that came out was brought out as essentially a concession in order to combat the lead charge. So I think that it might be a miscarriage of justice to try him on that particular issue, having given testimony in order to defend against a lead charge, to then convict, to continue to convict in an already perverted trial process on sort of a tertiary charge.
So you're saying there needs to be a retrial on that, on everything?
I would.
Is it possible to simply, not simply, but if we agree with you on the first issue, vacate on the primary charge but only do a resentencing on the felony in possession? Do you
I think
that's legally permissible?
I'm going to be honest with you. I would need to further brief that issue. I defer to my co-counsel
Yeah,
on that,
Understood.
that question. Yeah. I don't want to talk. I would love to give you an answer to that. I do
you
not
have an
the
answer? I'll use my discretion. Do you have an answer?
Yes, I believe he always, as much as conceded, the felon in possession charge. So I don't think we know, all of our, I think that it's not, that it was harmless there with regard to that. I think we should prevail on the sufficiency, so, you gotta reach the sufficiency first, and then the evidence was insufficient, then there's no retrial on the murder charge. But at the very least, if you find for us on the instructional issue, you can set it back for a retrial, but you would also have to consider a resentencing, felon in possession, because it's just way out of bounds.
Right, but with that's a possible outcome is what you're saying, is that vacate on the murder, resentence on the felon in possession.
Yeah, for two reasons. Number one, the PRB 7 would be changed.
Yeah. Disproportionate. Understood.
Do you have case law to support?
I'm sorry.
Do you have case law in support of that?
Well, I believe it's people versus Jackson. Or
Yeah,
Okay,
Jackson.
thank
that's-
you.
Yeah, that's the case. That's the case I found. And just what, yeah. So,
Okay. Okay, all right. Thank you.
thank you. Good preparation.
If there aren't any further questions, and appreciating the save from supervising counsel, I appreciate the
He
opportunity.
told us to throw that curveball, and so he was all prepped for that.
He told me don't worry about it.
Yeah, so,
So thanks for that.
All right, thank you. No further questions? All right, thank you. Nice job.
Thank you both.
That case will be submitted. Now calling item number 18, case number 370378, People v. Highland. We're good. I'll get yelled at later for it, but I think we're good.
No, you'll be fine.
Yeah, yeah. Council, please, Appellant Napoli, please state your appearances for the record.
Yes, Matt Wade from the Jackson County Prosecutor's Office on behalf of plaintiff.
Like this, that for, not a vote,
Answer any questions? We'll see. Don't push your luck. Don't push your luck.
Discretion only goes so far.
You may proceed.
Good morning. Given that further counsel is not endorsed, it's a pretty straightforward sufficiency of evidence claim. So I don't have anything to add to the briefs, but I'm here to answer any questions the court may have.
Any questions?
I have no question.
No questions.
All right, we would just ask the court to affirm. Thank you.
All right. Thank you. Good argument. That case will be submitted. Moving on to item number 19, case number 366385, People v. John Henry Lewis. Council, please approach. We have appellant endorsed for oral argument and penalty for the appellate. So you may proceed. State your name for the record.
Good morning, Your Honors. Roman Tishkevich on behalf of Mr. Lewis. First of all, Your Honors, in this case, we had several motion hearings, a Ginther hearing, 3 briefs, two supplemental briefs before the trial court. And unfortunately, the trial court did not state any reasons for denying the motion for new trial. And the prosecutor asked for a remand under the court rule or thought maybe that would be the best in this case. And that's under the MCR 6.431B, since the trial court did not state any reasons for denying the motion for new trial.
Well, actually, the trial court did, didn't it? I mean, it certainly could have said a whole lot more, but it said, I don't find ineffective assistance of counsel. That was its reason. It didn't say factually why it had reached that conclusion, but it gave a reason, didn't it?
The trial court did give a reason. It denied the ineffective assistance of counsel. And then the next 2 pages were reasons over the resentencing issue, which he was already resentenced months before and received a substantial time cut. So I'm not sure what that was. I really was not sure what was going on in this case, but if I believe if the court, since we did have a Ginther hearing, we had an evidentiary hearing, we have a record. We have a pretty good record in this case. We had the trial counsel testify. And I think the controlling issue is the People v. Barrara case. It's the 451 Mich 261 1996. And it's specifically analyzed when 804B3, which is now 4, the exception to the statement against interest can be allowed into evidence. And in this case, we had the co-defendant, Mr. Blackmore, who gave a statement that was clearly against interest, and it was our Exhibit B. There was a statement he gave to the investigator, and he was unavailable to testify as a witness. He pled the fifth, and that's clearly he's unavailable to testify at that point. And the Supreme Court in Barrara highlighted how that's admissible. They go through it. It only requires to be probative against a declarant, only probative of an element of a crime. Would a reasonable person realize that the statement's incriminating? And they're saying it just has to be a brick. He doesn't have to admit that he's guilty. It just has to be a brick in a wall of proving his guilt. And in this case, Blackmore's statement was very clear. He did not recognize Mr. Lewis. He was shown a picture of him, then recognized him. He said, I knew him around town, but I had no prior dealings with him. He had dealings with him on May 5th. And then he said, I was at Union Park selling drugs. This is what Blackmore said. He said he happened to be sitting next to him, and he asked him if he wanted to make some money. I gave him a package to give to the white truck, gave him $20 for doing that. And he said he did not tell him what was in the package. It's clearly against interest. He took the fifth, although he pled guilty for that charge, he was still going to be sentenced for it. And Mr. Blackmore also said he couldn't remember what the package looked like. He goes, they asked him, well, could you see what's in the package? He goes, I can't remember. So it wasn't a self-serving statement. And then we look at corroboration under the court rule, under 804B4 now. And the corroboration is pretty specific in the jury trial transcripts. Detective Howard on page, and we list that in our brief. He said he'd been following Blackmore. He was involved in previous drug deals with Blackmore, and Mr. Lewis's name never came up. He said he never saw Mr. Lewis involved in a previous drug deal. He said Mr. Lewis never got in the car with Mr. Blackmore. And Deputy Haskins, who was in the white truck, who received the package, also said that the package was dark. He could not see it.
Counsel, let me ask you just a procedural question. It kind of goes back. I think we understand the facts of the case as it applies to the three claims that you have for ineffective counsel. Should we not, but for what Judge Boonstra said, should we not first send it back if we agree that there needed to be more explanation by the trial court judge? Should we not first send it back in the first instance? Or do you say, no, the record's sufficient? Because I think if you're saying the record's sufficient, if you couple the record with the statement Judge Boonstra said, why is that not enough to meet the requirements of 6.431B?
Because I think 6.431B says that the court must list the reasons for denying, state factual reasons why he denied the motion for new trial based on this issue, the 804B3 issue. And the trial court, I believe, saying, I don't find ineffective assistance of counsel. And then the next 2 pages going into the sentencing.
It would leave us to speculate. Is that what you're suggesting? We're speculating at this point. We would be doing a de novo review based on the record.
Yes. Yeah. I believe that this court would be doing a de novo review, speculating on what the judge meant. And I think but we do have a record, right? We do have a pretty good record on this. And Yeah, the court would be doing a de novo hearing.
Don't we do that all the time?
Right, right. The court does.
We can assess, we got a pretty complete record, as you say.
Yes.
And we can assess whether there was ineffective.
And I
whether-
think-
Whether the facts as shown in that evidentiary record supports the trial court's conclusion that there was not ineffective assistance.
I believe the court can. I think the record is complete in this case. And if it's remanded back, I think it'll delay it for another year, I believe. I think it'll be a long time. We might have another motion hearing or another brief. I'm not sure what the court would ask at that point. So I do believe that the record is clear in this case, and I think the court can make a determination without doing the remand back to Judge Lasada.
Isn't generally the record pretty clear? I mean, that would assume that in all cases, there's an inter-hearing. A judge would just need to just say, don't find it. Just use the statement that you say, right?
Well, I wouldn't encourage it.
Yeah, you would encourage it, but I was just asking that question out loud.
It's very hard when we're after a Ginther hearing, when we're raising ineffective assistance, and the standard is, did they abuse their discretion? And it's hard to say, well, the judge made a wrong factual determination on this point or that point. We can cite to the transcript. And if a judge says, I just deny it, and especially when we brief the specific issue in detail and we had a hearing on it, it's hard for me, to cite to the record, or to say, they abuse their discretion for this reason or not. But I think because of the posture in this case of the 13 months we were down there, that I think the record is complete in this case to make a determination on the ineffective. And then we have the other issues as well regarding Mr. Blackmore, that he testified at trial that he had a conviction when he did not have a conviction.
That was kind of weird, wasn't it?
Yeah, and he was saying it was 17 years ago, and that's why we got the substantial time cut for him, because they charged him as a supplement second, and he never had a conviction. And he goes, yeah, my judge and the attorney, or the prosecutor and the attorney are telling me I have a conviction. I told him I didn't, and that goes to the ineffective, as it's a compilation or compounds. So.
Any further questions? Anything else, Joe? Anything further you want to add?
Nothing further. Thank
All
you
right,
so much.
Thank you. That case will
Thank
be
you.
submitted. Now calling item number 20, People v. Joseph Albert Pohl. Counsel, you may approach. I don't see anyone approaching. Did we?
It's on Zoom.
Oh, Mr. Simon's on Zoom. Thank you for noting that. I always forget to check that. We bringing him in here?
Good morning.
Good morning. Good to see you, Mr. Simon.
Good morning, Your Honor. Please the sound of the court. Jonathan Simon, P 35596 on behalf of Mr. Pohl. People are not endorsed. In fact, I don't believe they even filed a reply brief. This is a situation where my client, as the court knows, was charged with possession with intent to deliver narcotics. He was found guilty of lesser included offense of simple possession. This occurred in a vehicle operated by Mr. Pohl and occupied by two other people. The narcotics were located in a container which was not even closest to Mr. Pohl. There was no forensics, no fingerprints, no DNA. There was no confession or admission. There was a review of a cell phone believed to belong to him, which contained what was believed to involve indications as to narcotics trafficking. But apparently that was disbelieved given the fact that the reduced charge was found by the jury. Quite simply, we don't believe that there was sufficient evidence, even that there was simple possession of the narcotics. We asked the court to vacate that conviction.
Okay, counsel, go ahead.
Go ahead.
I got one question is, in your brief, and you cite rely on the Davenport rule. My understanding is that's no longer good law. do you concede that, you know,
Well,
since, since the early 2000s, the Supreme Court has said, the prosecution doesn't need to negate every reasonable theory consistent with the defendant's innocence.
well, certainly it is of an age but I don't know that it was specifically overruled. It also involved a similar situation, multiple persons in a vehicle where there was, I think in that case, a gun. Um, and so I think the same principle would apply. There's a lot of people, there's one container, and there's just an arbitrary decision as to who to blame it on.
Well, I given the text, I don't know that that's true. And I mean, I don't think that there has to be physical evidence of guilt because our case law permits us to look at circumstantial evidence and reasonable inferences arising therefrom, as in the Hardeman case where drugs were found inside a dress in a closet and there were two people inside of the house. It's the same thing here. You have, I believe it was 3 people in the car, and you have him sending the text and it's his car. I mean,
Text messages, I'm sorry to interrupt.
well, I mean, I'm reading the text messages right now. I'm not going to say it, but I'll substitute the word, your stuff is safe and I'll be there as soon as I can.
And those messages, I believe, were days earlier. And, so that could easily have pertained to something completely different. There was
For a jury to decide whether it's reasonable, the circumstances suggest that is reasonable to attribute that your client was aware of what the stuff was.
Well, those messages seem to indicate a delivery, and the jury found that there was no intent to deliver. So I don't know that the jury relied upon those text messages or even thought that they were persuasive. Again, they were a couple days earlier, and there was really no, I think, indication as to what substances they were. There was some so-called expert testimony from a police officer indicating what he believed that those to mean, but there wasn't even real proof that it was Mr. Pohl's phone. So I don't know. It seems like that evidence was completely discounted by the jury.
Any questions?
Well, I don't think it was completely discounted because they convicted him. Maybe lesser, but and all of this was presented to the jury, and our standard of review requires us to make all inferences in favor of the jury's verdict. So it's a very high standard.
I think that the verdict may have been more based upon the fact that he was the operator of a vehicle, which he said he had purchased, but it was not titled to him. And in fact, I don't know that he could title it because he doesn't have a valid license. But it seems to be that. I'm
Right.
sorry?
No, just, yeah, interesting times. As you said, he doesn't have the ability to do it, but he got it done somehow.
Well, no, it wasn't. He said he purchased it, but he didn't title it. And I think that maybe there could have been a finding that anything in that car, may belong to him because he says it's his car.
Anything else, counsel?
Nothing further on to this matter, Your Honor.
All right, thank you. This case will be submitted.
And you're staying on with us.
Yes.
Now calling case number 21, People v. DeWeese. Mr. Simon, you stay where you are while the prosecution, who's a endorsed appellee, please state your appearance for the record.
Yes, good morning. May it please the court, Brandon CCI, on behalf of the appellee.
All right, thank you. Appellant, you may begin.
Yes, this is a case involving issues which may have already been decided by this court. And I don't know how much discretion the court has to conflict, to convene a conflicting,
You
basic.
can ask me, Simon. I don't think it's going to happen for you here, but just
Well,
speaking for myself,
Mr.
I understand, 7-2 7.215J1, we're bound, so. And I
Sessions
don't,
believes
and I
that-
don't disagree with Burkett, so I see you want to go up to the Supreme Court, that's perfectly fine.
Well, I would encourage Mr. Sessions to do so. We believe that the mandatory minimum of 25 years, because he had a prior assault of conviction, is it's cruel and or unusual, and that it also violates the Separation of Powers Act, because we don't believe that the legislature should dictate what the court may do in terms of sentencing.
Well, I think the Constitution might disagree with you there because it puts the power to set the punishment with the legislature, but that's just me.
I want to make sure I have the record clear on this case. Your client did have 12 prior felony convictions and was on parole at the time of this conviction?
Yes, I believe that's what's indicated in the pre-sentence report.
Okay. Thanks. I just wanted to
We're
make.
not arguing that it's disproportionate. We are arguing that it's cruel or unusual.
Right. Okay. Nothing further? Counsel, you may approach.
Thank you. I've got the feeling I might not need to really say anything, but let me just,
Sometimes that's the best course, but go ahead.
do the judges have any questions
It
for me
doesn't
today?
stop people.
Are there any questions?
No questions from me.
I don't have any.
Thank you all.
Thank you, counsel. Well argued.
Well, I guess I have no rebuttal.
Not much to
Any
rebut.
rebuttal? Again, nice rebuttal.
Thank you, sir. All right, see you next month.
Counsel, that case will be submitted.
Thank you, Mr. Simon.
Thank you.
Now moving to item number 22, case number 368-480, People v. Christopher Vanover. Counsel, please approach, state your name and appearance for the record.
Good morning, Your Honors. Kirsten Nunn from the State Appellate Defender's Office on behalf of Mr. Vanover.
Good morning, Your Honors. Ashley Prue on behalf of the people of the state of Michigan, Assistant Prosecutor with Genesee County.
Thank you. You may proceed.
Thank you, and I would like to reserve some time for rebuttal.
Got it.
Thank you. I believe that the most salient issue, keeping in line with the court's instructions, and this issue had to deal with the stipulation that the trial counsel agreed to concerning the other acts of prior sexual allegations that occurred when Mr. Vanover was under the age of 17. I believe some of the acts went back as far as when Mr. Vanover himself was 10 years old. Now, I know the trial counsel stated purpose for them acquiescing to this, the stipulation was to impeach the credibility of some of the witness. And while that might have been the intended purpose at the outset, the prejudicial effect of those uncharged other acts coming in went far beyond, I believe, that stated purpose, and ultimately served to bolster the credibility of the complainants to the extreme detriment of Mr. Vanover.
Help me understand why it wasn't reasonable to use those statements as an attempt. Even if we agree that maybe it didn't turn out the best, but why was that not a reasonable strategy that, we have to defer to?
Well, there were other avenues or mechanisms he could have used to impeach the witnesses to, I guess, get to that same stated purpose. As stated in the brief, there was, less prejudicial, meaning like the police reports or prior statements made during, a prelim where he was trying to, show the jury where they may have said one thing before, they're saying this now. There were other avenues to go other than admitting and stipulating to evidence of
But
uncharged.
as counsel, is our standard to review it, yeah, there may have been 5, but was it unreasonable to choose maybe the worst one of the 5?
I'm sorry.
I guess
Okay,
it's
kind of cut off.
yeah, sorry. If there's 5 options to accomplish the goal of undermining credibility, is it really ineffective? Maybe the counsel chooses the worst of the 5, but it wasn't unreasonable or objectively unreasonable to take that strategy.
Well, I'm not sure how it's, I guess, not objectively reasonable to agree to allowing in a credibility case, like most CSCs are, it usually comes down to literally just the word of the complainants, and the accused. And so I don't know how it's objectively, reasonable to at least agree to allow almost unfettered or unchecked, uncharged evidence to come in regarding your client of doing prior sexual acts that also entail, your client when your client too, was a minor. And I guess part of the issue here is not to just look at it in terms of the stip at that point. Part of why this becomes an issue is later on, even the judge and both trial counsel after the fact, now after the bell has been, as the bell has been rung, expressed a very concern that we are raising now regarding that information. And the judge herself I think right after the prosecution's close of their witnesses stated that she now too was concerned about Mr. Vanover's due process rights because of this evidence that had come in now over the course of however many days that had to do, with this allegation, because it had been testimony had been woven throughout the trial. Trial counsel then kind of follows up and also says, again, after the fact, yeah, now I too am actually kind of confused. And it almost, if you do a quick reading, and it's almost as if maybe if he had to do it over again, he might not have done it again, but he seems to have also had a different understanding, at least per what he said on the record, as to what this evidence was going to entail. I think it went much farther than he actually thought of. So to your point, I get it's a strategic thing, but I just don't think it's reasonable in a case like this, when it's hinging like that on the line, to allow that evidence to come in just unfettered and checked like that. I think in this case, it was extremely prejudicial. I think the trial court acknowledged and recognized that it was, and so did trial counsel. But at this point, it had already been out. You can't unring that bell once that bell, has been rung, so to speak. Additionally, because trial counsel trial counsel stipulated to this, this evidence, we didn't get, and I'll make sure I want to be clear, we didn't get at the time of trial the usual, record that is made when this type of evidence is sought to be admitted under the statute, which obviously would usually involve some discussion of the Watkins factors, but it definitely usually involved the trial court doing a balancing test under MRE 403. At the time of trial, that didn't happen, obviously, because trial counsel stipulated, so none of that had to be done. Now, admittedly, later, at the motion for new trial hearing on this case, the trial court did, acknowledge that at the time of trial, no balancing test engagement had been done because obviously there was no need for it because trial counsel stipped. However, at the time, the trial judge actually acknowledged that she didn't know how proper it was for the court to engage in the balancing test at that point, but nevertheless, she did engage in the balancing test in her own mind and concluded that she would not have allowed the evidence in based on whatever balancing test that was done in the trial court's mind. Now, I believe this court has made at least multiple pronouncements that I've seen in the case law that the appropriate time to do that kind of MRE 403 analysis and balancing test is contemporaneous at the time when the evidence is being sought to be admitted, not retroactively after the fact. So I don't think that this retroactive balancing test that was done by the trial judge at the time of the motion for new trial was appropriate. And it did, again, rob us of a full record of what that might have looked like. And she also acknowledged again, after the fact, that while she's acknowledging at the motion for new trial that I probably wouldn't have let it in, she also does double back and say that part of my determination of whether or not to let the evidence in would have hinged partially on what his objection would have been, but we don't know what that was because trial counsel didn't make that objection.
Doesn't the record reflect that the defendant himself agreed with the strategy to slip?
The defendant did agree, but I would also state that, just as a human nature standpoint, the defendant is not a lawyer. The defendant retained trial counsel to be a lawyer and be an advocate on his behalf. So he trusted his lawyer when he said this was the way to go. And I would argue, I think most people and sitting in that seat would trust their attorney, especially at the outset. Now, eventually, even Mr. Vanover realized this was going off the rails, but at this point, the trial is kind of going on and there's nothing more that he can, do about it. But yes, he did. He agreed. He trusted his attorney's advice that this was the best route to go. So yes, he went with that, but I don't think that's necessarily fair to put a whole lot of weight and put the onus more on him. He is the client. Trial counsel was the attorney. He's the one that is supposed to know better what is a better way to go as opposed to the client. Unless this court has any other questions, I will reserve my time.
You have time for rebuttal.
Yes.
Thank you.
Thank you.
Counsel?
Thank you, Your Honors. May it please the court, Ashley Prue on behalf of the people. Items to highlight based on the briefs that I have. The court knows the standard, but I would be remiss not to say it. But ineffective assistance, and when determining if an action or inaction by counsel was trial strategy, this court is not only required to give defendants trial counsel the benefit of the doubt, but it is also required to affirmatively entertain the range of possible reasons that counsel may have had for proceeding as he or she did. And that was in Giglio. The trial counsel here laid out for this court and the trial court what it was doing when it very clearly put on the record that he had entertained discussion for the stipulation with the defendant. I believe the testimony he elicited from his own client was that he had spent days and hours going through it. They weighed the pros and cons. It was very clear trial strategy. And I do believe a portion of the record needs to be clarified based on the briefing and oral argument. The facts as presented by defendant in the brief regarding that mid-trial objection conversation, there was a whole conversation about this in volume 5, pages 90 through 110. Specifically, it kind of highlights in 98 through 100. But to get the whole idea of what was going on here, it wasn't necessarily a concern that the testimony had been there. It was the concern that the jury may have some slight confusion about whether these other acts were charged offenses. And even in that discussion, so both at the beginning, in the middle, and then at the end in closing, defendant's counsel very clearly lays out that he was trying to question the timeline for the charged offenses. He does that not only through the stipulation, but also in the hearsay testimony, the couple comments that come in. When you see on cross and take this record as a whole, it's very clear counsel had reasonable strategy. In fact, it led to an acquittal of one of the charges for CSC committed against Mr. We have to use the first name Dustin because they both have the same initials. So to say that this was unreasonable is just, it's not objectively unreasonable. I do want to also mention, we did file supplemental authority regarding the SORA issues. I don't believe this court needs to address them at this time. But if there were any other questions that the court had, I would entertain them. But other than that, I would just simply rely on our brief.
Questions, Joey?
Thank you, Your Honors.
Thank you, counsel. Rebuttal?
Just briefly, Your Honor, I would just like to point out that as it relates to count 6, which was one of 2 counts that actually Mr. Vanover was acquitted of, I do not think that you can say, or at least definitively say that the stipulation was the sole reason for the account, for the reason that that count was dismissed, because you didn't need this prejudicial evidence by the evidence to get to these dismissals. All trial counsel would have had to do as it relates to count 6 was merely just point out that Mr. Vanover was outside of the age ranges for these offenses. That didn't involve having to go into any other of the presidential evidence. It just could have clearly stated count 6, which was CSE 2, second degree, and it related to Dustin Thompson, had to do with, a person under 13 and the defendant being 17 years or older. By Mr. Dustin Thompson.
Please don't use his name.
I'm sorry. Well, she had already said it. So I thought it was okay. I'm so sorry.
Yeah,
I got it.
Thank you.
She used his,
Mr. Thompson.
she used one of the first names, but yeah.
Clayton.
please stick to
My
initials.
apologies. My apologies.
Yes, that's okay.
The count 6, the complaint that was related to count 6 by his own testimony, the alleged abuse against him stopped after their grandmother died in either 2000 or 2001. Mr. Vanover was born in 1985, therefore that would make him 15 or 16 in 2000 or 2001. So the point I'm making is all he would have had to point out to do is that that particular element wasn't met under that particular count because he was actually himself under 17 for that. I don't think that you can say that it was merely because the stipulation came in and all this other stuff came in to attribute the dismissal of the counts for that. Just wanted to clarify that. Thank you.
So thank you.
Understand your point.
Yeah. Understood. Thank you, counsel. That case will be submitted. Now calling item 23. Case number 363564, People v. Reed. Counsel, please approach. State your appearance for the record.
Michael Vroan on behalf of Mr. Reed. We raised 4 issues on behalf of Mr. Reed. There's a lot going on in this case, a lot of witnesses, and some of them share the same name. Tried to cover everything in the brief, hopefully in a way that's readable. I'll largely stand in the brief. The only remark I want to make is that the prosecution does concede at issue 4 that if the court reaches that issue, it should be remanded for resentencing. And, if they're listening, we appreciate that anytime they make a concession of error. Hopefully, on Mr. Reed's behalf, we ask the court to remand for a new trial. That wouldn't be necessarily a win for Mr. Reed if he got a resentencing. I understand they've got an argument that it's not going to make a difference in the long run. We don't agree with that, but that's something that has to be resolved at the circuit court level if we reach that. Other than that, I would stand on the brief unless the court has any questions for me.
Questions, Judge Butler?
Oh,
Okay,
okay.
No questions. Thank you.
Thank you.
Well briefed. That case will be submitted. Item number 24, People v. Vandermel. Council, please approach and state your appearances for the record.
Good morning, Your Honors. Emma Lawton with the State Appellate Defender Office on behalf of Mr. Vandermel. Mr. Vandermel is here in person today.
Okay, thank you, Council.
Amanda Ingram on behalf of Kathleen.
Thank you. Proceed, Council.
Good morning, Your Honors. I intend to focus today on issue 1. I'm happy to answer questions about issue 2 and issue 3, but issue 1 is where I intend to spend the majority of my time. Trial counsel in this case embarked on a defense that asked jurors to believe some of the complainant RR's statements that she had seen Mr. Vandermel masturbate while she was in the same room, and disbelieve other statements by RR that Mr. Vandermel had touched her inappropriately. This was a defense strategy that had something to it. As Dr. Swerdlow-Fried has explained in his report, there are reasons to doubt the statements that RR made and the credibility of those statements about being touched. There's reason to believe that those were suggested. There's reason to believe that those are false memories. Not necessarily that RR was lying, but that the result of questioning and the experiences that she went through after her initial disclosure to her teacher led her to make suggested statements. But trial counsel never investigated the possibility of consulting and actually calling an expert like Dr. Swerdlow-Fried to testify at Mr. Vandermel's trial. And that's what this defense really needed, because jurors struggle to understand why a small child might make these types of allegations. And they struggle to understand how to evaluate the credibility of these statements, because we know from studies that jurors' inclination is to evaluate, do I think this person is telling the truth? They tend to look at a person's demeanor, look at the way the person
How old
presents.
was this child?
At the time of the allegation, she was 5. At the time of trial, she was 7, which, as Dr. Swerdlow-Fried's report describes, puts her right in that target range for developing false memories and retaining those false memories. Because there are studies in Dr. Swerdlow-Fried's report talking about children from the age of about 3 to 6 years old. That in those studies, what they've shown is that children are susceptible to suggestion. They can be asked a question, a leading question.
Really, as a parent to children, I know that children of that age are suggestible. I think jurors know that children of that age are suggestible.
I think the case law of this court and the science says otherwise, that jurors are inclined to look at the child and ask, does the child believe they are telling the truth? Dr. Swerdlow-Fried talks about that in his report, that this is not something that is within the layperson's ambit. And that's something this court recognized in Ray Casto, which was a case where trial counsel asked jurors to believe that a child was not telling the truth. And this court said, this is something that requires expert testimony. This is something that jurors are not inclined to believe just on the basis of a layperson or an attorney arguing suggestibility to them.
So are you suggesting then that every trial that involves this, you've got to have, wouldn't it then say that in every case you need to have this expert testimony because, jurors aren't capable of making that determination on their own based on the evidence?
Not necessarily in every case, but in this case, where the defense is to argue that this is suggested and is specifically a defense that requires saying some of this is true and some of this is false. Jurors need to know, how do we determine what is true and what is false? And when we
But
look
isn't
at,
that the case in every case? I mean,
I don't think that sometimes the defense is going to be, it wasn't me. Sometimes it's going to be, the defense is going to be, this person is lying. This defense here involves saying some of this is true, some of this is false, right? It's a split argument about the allegations. You should believe some of what RR says. You should not believe other things that RR says. And so the jurors need an explanation for why should we believe that some of what RR says is true and what some of RR says is false. And what that requires is for the jury to really dig into these allegations by RR, right? Because you have three, well, you really have four. The teacher asks, were you ever touched? And she says no. Then in the first CAC interview, RR says, he grabbed my butt. It was only one time and he wiped his penis on it. And it was my, what she calls front butt. The second CAC is completely different, right? The second CAC is my back butt with hands. It happened many times.
why isn't it then sufficient to just point out the three discrepancies that you just pointed out? Why was it deficient to not call a expert on suggestive answering? Why is it not just sufficient for trial counsel to say, you know what, I can point these discrepancies out without an expert?
Because what jurors need to understand is that this is evidence that all of these statements are false, right? They're being told this child has admitted some of this is true. And so jurors can very well look at this array of statements and say, well, this is just a description of a lengthy period of abuse. But what Dr. Swerdlow-Fried explains is that actually what this shows is because the core details are changing, this isn't somebody describing multiple instances of abuse. It's not somebody giving varying accounts of the same instances of abuse. It's a person who is not able to search their memory and find a memory of abuse. They're describing something that has been suggested to them, and that is why it's so changeable. That's what jurors don't understand. And it's also necessary because I think it is, although trial counsel embarks on this strategy and he talks about it, he does not do the in-depth analysis that is needed of these three statements if he's going to do this. As the prosecutor's brief points out, he slides very quickly past the question of exactly what RR said. He's on this strategy of RR is not telling the truth and this has been suggested, but he really doesn't make an effort to explain why to the jurors, and jurors need that. The other reason an expert is necessary is because the prosecution has the benefit of the testimony of Ms. Barr, Augustina Barr, right? And the prosecution points to Ms. Barr and says, that's why you should believe what happens in the forensic interview, because Ms. Barr elicited these comments through a reliable process, through this scientific process of the forensic interview. That's why you should ignore the initial statement to the teacher that RR was never touched. And that also, and this is what this court talks about in Enright Casto, that's why you need a defense expert to counter the weight of the prosecution's expert. Because what the science actually says is that initial denial to the teacher is probably the most reliable thing that RR said. Because it is made in a non-suggestive context, and it's not made after this lengthy period of therapy of imagination-based devices. The prosecution itself and even the circuit court concede it's conceivable that expert testimony would have been helpful to this strategy. At minimum, a Ginther hearing is needed, and that's what we had requested in the circuit court, and that's what we've requested again here. But I do believe that the information in this case and the information from Dr. Swerdlow-Fried and that we know from the trial merits a new trial on this issue. If the court doesn't have questions on issue 2, I'll reserve my remaining time for rebuttal.
Any questions? No questions. You have time for rebuttal. Thank you.
Good morning, Your Honors. May it please the court. Amanda Ingram of the Kent County Prosecutor's Office on behalf of Plaintiff Appellee, the people of the state of Michigan. Just before I get into issue 1, I would like to point to issue 3 and, of course, how previous counsel has also said People v. Cardaz, it's Supreme Court number 165008 has, they denied leave on the lifetime electronic monitoring. However, it is that very topic is pending oral argument in the Supreme Court. now. Cardaz did hold this, the Supreme Court did hold, though, that the 2021 SORA is not cruel and unusual punishment, cruel or unusual punishment. So we still rely on our given case law. So regarding child memory and suggestivity, I would still counter that, you know, to Judge Dribblecock's point, not every case requires an expert on child memory and suggestivity. It has been a hot topic lately, but it just doesn't follow that every case needs one. And in this case, it was not required. To Judge Ledica's point, yes, we had parents as jurors, and it is lay knowledge that children will sometimes make up stories. How do we assess children's credibility? That was very well covered in voir dire in this case when we were talking to different parents. Do you have children? What are their ages? Do you believe you're a good judge of their credibility? I would also like to point to then the whether in this case it was actually suggested. Was there anything in this case that suggested to RR what happened? Ms. Barr's question was the first evidence of any of this. Other than, you know, she said the teacher, you know, has anyone else ever touched you? No. Okay, well, Ms. Barr's question was, has anyone ever done something? Has someone ever done something to the butt that you pee with? That to me, you know, maybe it is just to me, I don't know, but that does not suggest, did anybody's put their, you know, anything in it? Did anybody, you know, it just does not suggest the answer here. And in the key difference, the key case that was cited in appellant's brief, unpublished, People v. Carver, number 328157, when the mother found a speck of blood while wiping her child, she specifically asked, did somebody touch you inappropriately? That might suggest an answer. And in Ray Casto, 344 Mishap 590, a key difference was that there were accusations that the mother was influencing the child to create stories against the father. And whenever the child did make a disclosure to the therapist would tell him how proud she was and how brave he was for telling her. That's at page 597. So in contrast, though, this court or panels of this court have otherwise held in People v. Lizat 365-884, this was January 2024, for instance, respondents' counsel may have reasonably wanted to avoid the possibility that an in-depth analysis of NL's memory and testimony may have corroborated NL's memories and the trustworthiness of her testimony. Thus, it is reasonable that respondents' counsel may have wanted to avoid the possibility of confirming NL's allegations. Appellee would submit that that is exactly what happened here when trial counsel's strategy was to point out, you know, place as much emphasis on as possible on this other case to which defendant readily admitted as proof, as to be able to show that, but here her story varied. This isn't as believable, and he denies it. So I would leave it at that unless there are any questions.
Questions, Judge Lang? No questions. Thank you. You
Thank
have time for rebuttal.
Thank you, Your Honor. Just a few quick points. First, that Ms. Barr's question was suggestive. That is how that type of question is classified in this type of evaluation of forensic interviewing. The question doesn't have to necessarily result in a specific answer, but when a question is suggestive, it means that it is prompting the child to give an answer that goes to what the question is asking. What Dr. Swerdlow-Fried explains is that children under those circumstances start to make up details. And we see that in this first forensic interview with RR.
Is there a case law you can point the panel to that says, okay, here are questions that are suggestive versus here are questions that are not?
People versus.
Or are we to just rely on the the report of the experts?
I think there are two aspects kind of to that. There is People versus Gursky, which talks about leading questions and suggestive questions in the context of questioning small children. That's in MRE 803A. And I think my reply brief talks about how it makes a distinction between questions that might be leading if an attorney asked them versus questions that are leading to a child in a sort of parent-child questioning context. So I think People versus Gursky goes to that, right? It does list out some questions that would be examples of leading. But the expert testimony here and the expert definition of what leading matters, because this isn't necessarily the word leading in the legal context. This is leading in the context of do studies show that this type of question prompt a child to confabulate?
Help me understand that. Why was defense counsel cross-examination of Ms. Barr? Why wasn't that sufficient? Why is that, why did you need an expert, or why are you saying it's ineffective to not bring an expert? I mean, defense counsel said, is it fair to say that you never test the veracity of what the child's saying? Answer, I'm not a human lie detector, so I can't tell if someone's telling the truth or a lie. So then he says, okay, so you're not telling this jury that any of that was true, just that's what RR said, correct?
So I think, Your Honor, that goes
Why
to...
is that not, why is that not sufficient to address the concern?
Because that goes to a different point. What counsel is doing there is really going to Thorpe, right? Which is that an expert cannot say, I know this is true. But what he's not doing is demonstrating to the jury why this forensic interview was deficient. It was deficient because it failed to conduct any alternative hypothesis testing, and it failed to test not the ultimate question of, is this statement true, but are these statements reliable? And that's what the jury's not getting. That's in Dr. Swerdlow-Fried's report, right? It's talking about the answers of I don't know, I don't know, I don't know, which never get tested in the sense of, is this I don't know because I don't have a memory? Is this I don't know because I'm uncomfortable? Is this I don't know because I'm making this up? And I want to stop making up the answers, right? That's what the jury doesn't get to hear. The jury doesn't get to hear that this forensic interview actually fails to follow the forensic interview protocol because there's no alternative hypothesis testing, because it is asking more leading questions. Ms. Barr is not confronted on any of those issues in trial counsel's questioning, because trial counsel really is just making that point in Thorpe. You're not telling them it's true. They still have to decide whether or not it's true. That's different from what Dr. Swerdlow-Fried is talking about. And that's why leading in the context of this child forensic psychology matters.
I think trial counsel also ask and close this question with, well, the child forgot several key elements several times. Isn't that correct?
He asks Ms. Barr that, but what he does not get out is that it's not forgetting, right? She's answering, I don't know. And that raises a question that a child psychologist should answer, which is, I don't know can mean this is not true. I don't know can mean I don't have a memory to access. And what counsel also fails to get out of Ms. Barr are the substantial changes in story. Every version of this that RR tells is completely different and often directly contradicts what she says before. And that is also something that jurors tend not to understand, is that children who are accessing a memory and describing that memory do not go back and contradict what they have said. They don't go back and say, it only happened once. Actually, it happened multiple times. Actually, it only happened once. It was the front. It was never the front. It was the front, right? That's what shows, and what trial counsel fails to get out. That's what shows is this is not an actual memory.
How is a court to balance then, and it's a little bit not the question before us, but where then that expert isn't substituting and telling the jury, believe this, don't believe that?
Because what that expert is doing is educating the jury about how to weigh credibility. It's ultimately the jury's task to evaluate, do they think that the lack of credibility in the circumstances of the disclosure make it unreliable? Dr. Swerdlow-Fried would not be saying, this is an unreliable disclosure. He would be saying, these are the factors that make disclosures unreliable. These are how those factors apply to RR's statements. And it would be up to the jury to draw the conclusion about what is or is not reliable and what they do or do not believe.
Further questions? No further
Thank you, Your
questions. Thank you. Very well done. Now calling item number 25, People v. Darius Holmes. We have Mr. Babcock endorsed for oral argument remotely and limited to 10 minutes of oral argument.
Good morning. Ben Mordecai Strongen here from the State Appellate Defender's Office on behalf of Mr. Holmes.
Can you state your name again?
Yeah, I am Ben Mordecai Strongen. I know Jessica Zimbelman was originally endorsed for this case. I think out there we swapped it.
Okay, can you spell your last name?
Yeah, it's a doozy. MORDECHAI hyphen STRONGIN. I probably got to change that. And it's P87106.
Thank you.
Yeah.
And we have Mr. Babcock. Can you just, Mr. Babcock, can you state your appearances for the record?
Yes, Your Honor. Russell Babcock on behalf of the people.
Okay. All right, you may proceed.
All right. Good morning, Your Honors. May it please the court. This court is confronted with three closely related questions, each involving legal analysis and tightly intertwined with factual analysis. First question was Mr. Holmes, who was never given Miranda warnings, in custody. 2, did he invoke his right to remain silent? And 3, were his statements made involuntarily? I'm going to start with the custodial determination. As this court knows, we need to look at the totality of the circumstances de novo to determine whether a reasonable person would have felt that he or she was not at liberty to leave the interrogation or terminate the interrogation and leave. Now, the facts here are very complicated, and the prosecutor's brief presents a very different picture than what the record seems to reveal. And unfortunately, the trial court's order denying Mr. Holmes a suppression motion is largely bereft of factual findings. Those few findings the court did make are shown to be clearly erroneous by the evidence in the record, and I'll discuss that shortly. But here's what the evidence does reveal. Mr. Holmes was shot. He goes to the hospital, and the moment he steps into the hospital, hospital staff call police. From that point forward, at least 1 to 2 police officers, and sometimes more, are either by Mr. Holmes's bedside, asking him questions outside his door, or following him on the way to procedures.
Go ahead. We're probably about to ask the same question. Go ahead. You go.
So you're saying that he was in custody when he was at the hospital? That they're not there to say, oh my gosh, somebody's got shot. Let's see what's going on here. I mean,
Sure.
these could be unrelated. And at that point, I don't think that they even know that he's on their radar, right? They know that they have this other shooting, but it's been reported. So are you challenging that one?
So
the hospital one?
2 things. I'm challenging the voluntariness of the hospital statements, for one. And then, because regardless of if he's in custody, if his statements to the police are involuntary, they should be suppressed. They're used against him at trial as proof of his, as kind of impeachment evidence. But 2, the police officers aren't just there questioning him, hey, how did you get shot? They spend the entire 5 hours he is at the hospital, following him around the hospital, including even when he goes to get a CT scan. The police officers follow him to the CT scan, follow him back. And again, he's in 8 out of 10 pain. Recently having been dosed with 100 milligrams of fentanyl, and police start questioning him. And again, they spend the entire 5 hours with him. But, you know, to Your Honor's point, the bulk of the statements here occur at the police station, and I do want to focus the bulk of my argument on those police.
So they got it. So I mean, we have the videos.
Mm-hmm.
So they take his clothes, they take his phone, and he's seriously going to the police station in a hospital gown?
Well, I don't think he had a choice.
I mean, I know they took his clothes, but
But I mean, he didn't have a choice whether to go to the police station. I think that's evidence of the fact that this was custodial. We know from those records, from the audio files, Mr. Holmes was.
I get that the hospital records say that he's in the custody of the police. That just means he's with the police as opposed to, I
It's
don't.
not a legal determination.
You're
that he's in
correct.
custody.
Absolutely. I don't, that's not my point. My point is that it feeds into the custodial determination that he is transported from the hospital in the back of a police car to the police interrogation room. There is no evidence in the record to suggest that this was a voluntary choice. And in fact, this is one of the reasons we've asked for a remand, is because I think that trip from the hospital to the police station is something that needs to be clarified for this court. Mr. Holmes reports, although it's not a part of the record, that he was handcuffed, put in the back of a police station, and transported. This was not a voluntary choice to go to the police station. And in Barrett, the case where we get our Barrett factors, the court found that even being uncuffed, transported to a police station in the back of a police car by armed police officers.
Is there no, I didn't see it and point it to me. Was there any video of the transport in the car? I mean, often we get video records of, the dash cam.
Yeah.
Or the cam inside the car of the suspect in the back of the car. Is that not available, or is it just not been obtained, or?
I think that might be a question for Mr. Babcock. I don't have it. And I don't know that trial counsel had it. We have trial counsel's files and it's not in there. There are a lot of things here. For example, the videos of the actual.
If you got a question, fire away.
I want him to finish answering your question.
Thank you. I'm trained to respect you when you want to ask questions.
Yes,
so.
thank you.
Oh, sorry.
No. Keep going.
For example, the videos of the actual interrogation room. The police say this is being video recorded. We don't have actual, visual videos of that. There are a lot of things here that we should have that we don't. And Mr. Holmes reports in those custodial interviews, he is nodding off.
Was there a video? I mean, I don't understand.
That's me either. And I think this is why a remand is maybe important, because we should know whether Mr. Holmes was handcuffed and transported to the police. Regardless, we know that Mr. Holmes is taken from the hospital to the interrogation room.
And where he's told, you're free to leave.
Right. But he's also told, you don't have to answer any of our questions. And when he tries not to, I mean, Mr. Holmes makes 3 statements invoking, or attempting to invoke at least, his right to remain silent. First, police say, do you want to tell us how you got shot? Do you want to tell us what happened this morning? Mr. Holmes says, no, not really. Next, he says, the police continue asking, what happened this morning? What happened? What happened after you woke up this morning? Mr. Holmes says, I ain't going to talk about it. The police take a break from questioning him for about 2 or 3 minutes, according to the report, which isn't a part of the record, but we don't know how long that was. They come back maybe 3 minutes later. Mr. Holmes again says something along the lines of, I really don't want to talk about this. And so true, yeah, police say, hey, you don't have to answer our questions, but they also demonstrate the insincerity in those statements, because Mr. Holmes, even if these aren't invocations of the right to remain silent, he is clearly attempting to say, I don't want to answer your questions. And police aren't respecting that. They're saying, hey, you really should talk to us. In fact, you need to talk to us. You need to clarify some things. Moreover, at one point in, I believe it's video C3.
Okay, so how many times do they tell him that he's free to go?
I believe it's about 3 times at the top of a 90-minute interview. So in about 3 minutes, they say it 3 times. But in video 3, Mr. Holmes says,
Is it limited to the interaction? I'm forgetting this. Is it the sister? Is it the questioning about the sister?
so I'm not sure I understand the question.
I think the prosecution was saying that this was related to the sister.
Oh, you're talking about the right to remain silent question?
Yeah.
So they say, I believe the exact, I didn't write it down, but
I'm trying to figure out where that is in the record.
so the exact, oh, this is the video, all in the audio files. I say video, but they're audio files.
But right. But something happened before they got in the room.
Yes, this is at the hospital, which is a body cam footage, which I don't know if the body cam footage was reviewed by the trial court. But what I do know is at the hospital, Mr. Holmes makes statements talking about how he was with his sister. So then the police go to Mr. Holmes, start the interview saying, what happened after you got to your sister? Saying, we actually know what happened. We know how you got shot. And in fact, we talked to your sister and we know you didn't go to your sister's house.
Correct. Yeah.
But
They confront him every time he says something, but
Right.
they talk, they go check it out, they come back and they're like, "Oh, it wasn't that."
Right. And so they say, what happened after you left your sister's house? And Mr. Holmes says, I ain't going to talk about it. And the it there refers to everything that happened this morning. So that's why we would argue that's an unequivocal invocation of the right to remain silent. But regardless, again, it goes to your original question about, sure, they tell him he's free to leave. They tell him he's free to not answer their questions. But those statements are insincere because at one point, Mr. Holmes asks, I need to use a phone. He says, I need to use a phone. I need to call my family. I need to use a phone. And the police.
We have your phone.
Well, they have his phone, but he could use, a desk phone. I'm sure they still have those.
No, not now or something.
And the police say, no, you can't use our phone. No reasonable person would feel that they are free to leave if they can't even go and make a phone call.
Isn't it the time am I correct that he's sitting in a hospital gown
That's correct.
in the police station,
That's correct.
presumably in his underwear, maybe not?
We don't know,
Do
presumably.
we know any of that?
I mean, we don't know.
He doesn't have his wallet, doesn't have his phone.
Doesn't have a wallet, doesn't have a phone, doesn't have a car. We know it's raining. There is no means for him to leave, especially if he's not permitted to use a phone to call a family member or a friend. And we also know, by the way, going back to the Barrett factors, I mean, we've talked kind of around them, but we know in terms of the room he's actually in, the location and also physical restraints, that he's in a closed door interrogation room. And from the audio files that are, were submitted to the court, you can hear the door was probably locked. We don't actually, that's another thing we don't know, but you can hear the officers like struggling, jimmying the door handle and saying like, oh, I think it's locked. So Mr. Holmes would have known it's locked.
So am I right about the fact that this trial judge was just given these tapes?
It's like a 10-page record, and the only part of the record that was lengthy was listening to the first 10 minutes of the tapes. And it doesn't seem like the trial judge actually listened to anything beyond the first tape, which is a 23-minute tape. And I say that this is going back to where the trial court is clearly erroneous, because the trial court in its opinion says something
Right, it was a half an hour.
less than half an hour. And obviously, as Your Honor is indicating, that's not true. So it seems like the trial court didn't even listen to some of the important audio files, including where Mr. Holmes says, again, I really think this is important, I need to use the cell phone, or I need to use a phone, and the police say no, which I think is really key to the custodial.
It would be nice if sometimes these things were transcribed, so.
I don't disagree with you, Your Honors, and
I feel like we're doing a court reporter's job.
I don't disagree.
Yes.
But, right, so, I mean, that goes to the other Barrett factor too. Just the audio itself is 90 minutes. That doesn't include the time that we know Mr. Holmes is in custody, and it doesn't include the 5 hours he spent with police in the hospital.
Yeah, I mean, the timeline is very vague.
Yeah.
That's true.
And
how long are these breaks? And
exactly. And this is why, I mean, I really do believe the record is sufficient to demonstrate that Mr. Holmes was in custody. We know he wasn't Mirandized. I do believe there is enough for this court to suppress these statements and grant us a new trial. But to the extent, I mean, Judge Letica, you are finger on the pulse on an issue that is obviously frustrating to me as much as it is to you. There's a lot we don't know, but I do think we have enough that we know. And Judge Trebilcock, to your point, right, he is in a hospital gown, maybe in underwear, maybe not. And regardless, I think being in a hospital gown is also a really important factor, both for the voluntariness and for the kind of physical restraint aspects of the Barrett factors and custodial determinations. I mean, there is no means by which Mr. Holmes can leave the hospital. He is without phone, without clothes, without car, all of which were impounded by the police. It's essentially impossible for him to leave without, kind of the permission of the police. And, the police do ultimately.
They let him go for a week at the very end.
That's exactly right. And I'm glad you brought us here because the police do, of course, ultimately let him go. This court has held that, quote, the fact that the defendant was aware that she would be released at some point in the future does not alter the fact that until the release occurred, she was in custody. That's from People v. Rourke. It was quoted recently in People v. Prushka, not recently, in 2017. Mr. Holmes here did not know he was going to be released. So this is even more distinguishable than Rourke. You cannot, I don't think you can, I know it's a Barrett factor, but what happens at the end of an interview cannot inform how a reasonable person would have felt during the interview. He had no idea. In fact, you can hear in the video when they tell him he's free to go that he is like shocked. He is genuinely surprised. And I know it's not a subjective inquiry, but it still speaks to how a reasonable person would have felt. He is told this is an investigation for murder. He is told, we know you're lying, repeatedly. He is told.
Ultimately, yes, it's an investigation.
Well, he said that. I mean, they tell him that in the video, in the audio files. So it's not ultimately an
At what
investigation.
point was that though?
He is told that. This is why we would benefit from a transcription.
Right.
I think I have part 2. They tell him that he's dead.
Part 2, they immediately tell him he's dead. I think they don't say it's an investigation for murder until the end of part 2. So I think in the beginning of part 2, they say he's dead. The end of part 2, they say it's an investigation for murder at this point. And they say, if you don't talk to us, we're going to assume it's murder. I mean, they say things along the lines of like, we know you lied to us. We need you to be honest with us. We need you to tell us what happened. We know how you got shot. It could have been a spur of the moment thing. Talking to us will help you in the long run. You're not going to get another chance to talk to us. We know you lied. If you don't talk now, no one's going to believe you later. These statements all those statements, by the way, came out before Mr. Holmes started speaking. I mean, those are these badgering questions. There's 8 to 10 minutes of the police hammering on Mr. Holmes to speak when he is trying to invoke his right to remain silent.
We have the audio, counsel. Any other points you want to emphasize before we turn?
Sorry, I just want to emphasize one more point about release is relying on release alone to find that Mr. Holmes was not in custody. I think sets pretty dangerous precedent for the state of Michigan that we can't allow. If we let unmirandized, coerced confessions in just because a person was released at the end, police would be free to do that. You know, hey, we have a suspect for murder, but we don't want to Mirandize him. Let's let him out for 5 days and then we'll get him back next week. I don't think we can allow that in Michigan. It seems you were telling me I'm out of time, so I will.
No, if you've got a few more minutes, we're very familiar with the facts.
I know it. Yeah. Well, thank you, Your Honors. I'll just end by saying, you know, all of that we discussed relates also to the vulnerability factors, which is a kind of separate but obviously related issue. Again, he's vulnerable. He's in a hospital gown. He doesn't have his phone. He doesn't have his wallet. He doesn't have his car. He's in pain. He's dosed with fentanyl twice that day. The police officers are badgering him. And right, this court has held in People v. Henry, quoting the United States Supreme Court in Michigan v. Mosley, that persisting in repeated efforts to wear down a person's resistance and make him change his mind after he invokes his right to remain silent is not scrupulously honoring the right and is dangerous to a person's Fifth Amendment rights, and I would say due process rights as well. That's what occurred here. So I will, if I do have more time, I'll reserve it for rebuttal. But
Yeah, you have some time for rebuttal.
thank you very much, Ron.
Good morning, Your Honors. Russell Babcock on behalf of the people. First off, I think the important thing for the court to consider is, of course, the fact of the record that's been provided to the court, including the audio recordings of the interview. I think there's been a lot of characterizations made about what was the nature of the interview. I think, quite frankly, the audio is the best evidence, in addition to which is also further buttressed by the testimony that was provided at by the officers. I think the important thing for the court to remember, though, is this. And by the way, in conjunction with this hearing here today, the defendants did file a motion to remand. And by the way, we have stipulated that the phone and all that was seized. Obviously, it was evidence of a crime. The vehicle was disabled in part. It was parked in front of the hospital, so that obstructing it. So they removed it. But I think it's important. And they're not arguing, by the way, in their appeal, even though they try to raise it for the first time in their motion to remand, they're not arguing ineffective assistance of counsel. So they're not saying that his trial attorney didn't do their job. So we're faced with the record that we have. And everything, when you look at the record that we have, is that, number one, when you listen to the audio, and again, this could be my characterization.
Counsel, can you just pause for a second?
Can I stop you? I thought they were arguing ineffective assistance of counsel, that there were some things that they didn't introduce during the hearing. Am I wrong?
Not in their brief on appeal, Your Honor. Their issues are very clear on that. I can bring Your Honor's attention to those issues specifically in their brief. Their issues are very simple.
All right, go ahead.
So if you look at issues 1 and 2, not once do they mention ineffective assistance of counsel in either one of those two. So it's important that the court keeps that focus in mind because, again, it's been waived to the extent that they even claimed there was such an argument. Quite frankly, number one, you've heard all this conjecture about what may have happened, but what we do know is that this person was questioned at the hospital, and they admit it was very short, relatively short period of time. And then when they take him to the police station, and again, your court has the benefit of the audio recordings, they repeatedly said, hey, we'll take you home, we'll take you to where you want to go, you're free to leave, all this other stuff. And then
Counsel, your position is that at no point on that morning of the incident was defendant in custody.
That is absolutely correct, Your Honor. And he was free to leave at any given time. And again, remember, as pointed out, this gentleman was an HOA 4 status. So he was not, and he was in his late 20s. This person was not new to the criminal justice system. He had been convicted previously.
Do you know, counsel, and where would it be in the record, or do you know otherwise that was he handcuffed at any point?
No, my understanding is he was not handcuffed at any point. I'm not aware of any part in the record where it states he was handcuffed. I mean, that's, again, the record before the court is absent of any suggestion of that. So
Is there video available of, I didn't see it, or is there video available from the transport from the hospital to the police station?
I don't see any indication one way or the other about any video. Again, that was not part, I mean, the court has the record before it.
It's not in the record.
Yes. And also, when you look at the context of the statements made at the police station and so forth, it's clear that this person was not in custody. He was being told repeatedly he could leave, and he never stated otherwise. So when your honors look at this record, in fact, by the way, this is the first time I think I've heard anything about handcuffs.
Was he told he could call someone or that he could just leave? Because if he was given fentanyl and he was at the hospital, they would not have physically allowed him to leave the hospital without somebody to drive him. And
I would agree, Your Honor. They didn't. I mean, again, he was given a ride by the police.
At the police station, did they offer to transport him home? Or they just said, look, you can go, you can walk out of here and walk wherever you want in a hospital gown.
Well, there's no evidence that he was restricted in any ways. Again, the record doesn't suggest, nor did his attorney at the time of the hearing argue otherwise, that he didn't have the physical ability to leave the precinct.
But the police were aware at the time that he had been shot, he'd been treated at the hospital, he had been given fentanyl. Right? They were aware of all those facts, right?
They were aware he had treatment. I don't know if they knew about his medication dosage or anything along those lines. But the officers testified he was not visibly impaired in any manner during the questioning at the hospital and even at the precinct. And again, that's where the court needs to step back, and there's all this argument, conjecture being raised by the defense, but then you look at the record, and that's what we have before us. And again, no one's arguing ineffective assistance of counsel as to how that hearing was handled. So when you look at the record, Your Honor, it shows is a voluntary act. In fact, ultimately, he was transported to where he wanted to go at the end of the day. And there was never any indication.
That evidence, counsel, I'm sorry. I want to, if you could point me in the record, because I didn't see it and maybe I missed it, evidence of how the defendant, when he was ultimately left the interrogation room, how he departed the police station. Was he picked up? Did he walk? Did the police give him a ride home?
My understanding is the police gave him a ride home. One second here. I'll see if I can find that in the testimony here. They took multiple breaks. I'm looking right now, Your Honors. Let's see. Well, OS, I'm looking at the wrong brief. I'm looking at their brief. Sorry, Your Honors.
It would have had to come in at trial
Yeah,
if it's in the record.
yeah.
Yeah.
I didn't see it, but maybe I missed it. That's why I was asking.
Yeah,
Counsel, you can continue. If you don't know, we'll find it, but excuse me.
Bless.
If you knew it, I was hoping to find that point. Thank you. Go ahead.
Sorry about that, Your Honors. And in fact, quite frankly, I guess part of the problem is that no one's ever really disputed the fact that he was allowed to leave, was transported to where he wanted to go. I think even defense counsel acknowledged that during argument. Then he tried to argue that wasn't sufficient on the issue of custodial interrogations. But so, Your Honors, I mean, that's where we're at here, Your Honors. I mean, I guess at the end of the day, you know, he was an HOA fourth. He knew he knew the system. He made an inquiry. He made a comment about not wanting to talk about, I think it was coming out of his sister's house. I think that was a specific question.
Yeah, where was that in the record?
Yes, Your Honor. I've been trying to find that as well while I was talking to,
I was trying to find where that came from.
yes, Your Honors. And I know there was a question. Let's see here. Let me see.
I know you only have 10 minutes, so.
I know you're. Oh, I appreciate that.
And I've given you a little bit of leeway on that,
Yeah.
Counsel. So can you wrap it up, or do you have an additional question for him?
So if we were to find that there was error here at some point, I'm not saying at every point, but can it be harmless? Is it harmless? That wasn't in the briefing, your briefing that I saw.
Yeah. Again, I guess without knowing what the court would ultimately find, I mean, I think a situation could be where it is harmless, but part of the problem is I quite frankly fail to see how there was any error to begin with. So, quite frankly, again, I think what the court needs to do, and this is how I would summarize all this, is that what the court needs to do is focus on what's actually before the court in the record. I mean, until today, I mean, there was no objections at the trial court level about the defense counsel not being sufficient, providing arguments about how the hearing was handled, how the evidence was gathered, presented. No ineffective assistance counsel was ever raised on appeal. So therefore, presumably the record is accurate and complete. And when the court looks at the record, I think when you look at it and you look at the evidence that was presented, I don't see where anything can be indicated that there was a clearly erroneous mistake made by the trial court.
Counsel, Judge Ledica has a statement.
Except for the court's finding that the interview lasted less than half an hour, which is kind of a big deal here when we know that there are 5 tapes and it's more than 90 minutes and we really don't know the timeline. But I mean, to your point, I guess we can say we only look at what was given to the court at the time of the hearing, which was the tapes, and here you go. And if we find that was a clear error, that he erred on that factor, plus there seemed to be kind of a, I don't even know how to characterize it, a mixing of involuntariness and custody, and I'm not sure what exactly the court was looking at, and I don't know that the court had anything in front of it that said, well, the court knew at least they took his phone. And I don't know that the court even knew that that they took his clothes.
Okay.
Right.
Well, Your Honors, I guess this is how I would answer the question.
Okay,
Number
please.
one, with regards to the interviews, the one thing I would argue that is to the extent that the court miscalculated the amount of time of
Okay.
the interviews, that this court has the benefit of knowing how long the interviews are because the court has the audio recordings in front of it, which shows that it was less than an hour and a half at the precinct. So
After 5 hours at the hospital.
And you say
Well-
that, but there's breaks all the way along here and I have there's no times that, I mean, I don't know how long he was there, how long they were talking to these people between the breaks and getting, following up on his story.
And what the court is what I think where the problem is that the defendant, that would be a question of ineffective assistance of counsel at the trial court level.
Right.
And I think that they have not raised that on appeal. So I think that's the problem. The court must assume that the information is
All right,
accurate.
Counsel, you're over your 10 minutes unless there's any other questions with discretion of my colleagues. Do you have any other follow-up
I
questions?
have lots of follow-up questions, but not that can be
Not that can be answered with the record before us. All right, thank you. You have time for rebuttal.
Thank you, Your Honors. I will be brief, or hope to be. First, let me answer your question, Judge Trebilcock. Mr. Holmes was taken to his aunt's home by police. I don't actually remember where in the record it is, but I can say that confidently.
Okay, thank you.
Now, first, I don't disagree with Attorney Babcock. The best evidence is before the court. I do think the audio files speak for themselves, and I think they show that Mr. Holmes was in custody at least at the police station. We do argue ineffective assistance of counsel in our brief, which it seems like this court kind of was aware of. You can go to page 23, alternatively, trial counsel was ineffective for failing to present evidence available.
but I guess I don't see it in this. Well, I'll go
Statement.
back and look and see if it's in the statement of question presented.
Yeah, I went back and I didn't see it. There's,
Yeah.
But
I didn't draft.
it's in it's
the brief.
alluded to
It's
in the
brief.
briefs.
Okay,
So,
all right.
yeah,
I knew
that's where that came up.
Thank goodness I got it from somewhere. I'm not
You weren't
just
making it up.
Counsel should have brought up other evidence. We've talked about things that were missing. And to the extent that this court needs that evidence, MC, 211 provides this court the authority to, MC 7211, provides the authority to remand on a motion to remand when the development of factual record is required for appellate consideration of an issue. I agree, the evidence speaks for itself, but to the extent it doesn't.
It is what it is right now.
To the extent it doesn't, a remand is appropriate here. And if there are no other questions, I will.
Well, can you answer the prejudice question?
Certainly. The error here was not harmless. First of all, it would need to be proven harmless beyond a reasonable doubt. So the burden is on.
I understand the standard for.
Of course, I know you do, Your Honor, and I'm sorry, but I do.
Okay.
It bears
okay.
emphasis.
Yes, it does.
And
it is a high standard, but go ahead.
And even a lower standard, Mr. Holmes doesn't deny that he was involved in a shooting with the decedent.
Right, he says it was self-defense.
He says it was self-defense, or it could have been a lesser offense than what he was charged with, manslaughter. At some point, the police even insinuate that's what it was. And so really the case here, there's no other witnesses. The case here is exclusively built on Mr. Holmes's statements. I really don't think there could be an argument that with those statements suppressed, this could.
There's a kicking in of the door, right?
Glass in his arm.
In his arm?
Yeah.
There's but he is, I guess, to reach the standard of beyond a reasonable doubt that this error was harmless and that, the kicking of the door wasn't in response to being shot at first or wasn't in response to certain other things. There's a lot that the jury would have needed to wade through very differently had it not been for Mr. Holmes's statements, I guess is what I would say.
Anything further?
No.
All right. Thank you, counsel.
Thank you very much.
Thank you. Mr. Babcock, we got you again, so hang tight. That case will be submitted. Moving on to item number 26, case number 367-433, People of Michigan v. Bentley. Council, please approach. Ms. Lawton, state your appearance for the record.
Good morning, Your Honor. Emma Lawton on behalf of Mr. Bentley.
Mr. Babcock.
Russell Babcock on behalf of the people.
All right, you may continue, Ms. Lawton.
Good morning, Your Honors. And this case concerns Beck retroactivity. The Supreme Court is hearing argument in Beck next month. So I won't belabor those points of my brief unless the court has
Well, you know
questions
where
about
I
them.
am on this one.
I do, Judge Letica.
What's your position on, I'm just curious on your position about holding an abeyance versus issuing a decision consistent with our binding authority as it stands today?
Well, I did file a motion to obey.
Yeah.
And so I do think it would be appropriate to hold an abeyance and potentially order supplemental briefing after Beck comes out or after Moughton comes out, depending on what the outcome of that decision is. If the court prefers, I will file an application to the Supreme Court. So I think maybe for the sake of judicial economy, it makes sense to obey, which is why I moved for that. I do also think potentially supplemental briefing is appropriate based on the decision in Moughton.
Thank you. Mr. Babcock, but anything you want to add, and then let me hear your position.
Your Honor, obviously, we are all waiting for what the Supreme Court will eventually do on that particular issue, if anything.
Maybe. Sometimes they grant leave and then they just say,
Never mind.
JK.
Yeah.
And that's very possible. I guess the point here is that in the application for leave to appeal, the scope of the relief sought by the defendant was a remand to the trial court to have a successive motion heard. This is kind of a unique situation. He filed a motion to request permission to file successive leave. Quite frankly, under the Beck's current status, the trial court was no better position than this court, and denied his request to file a successive motion because there had been a change in the law that impacted him in one way or the other. So ultimately, if there is a potentially favorable ruling at the Supreme Court, then I suppose that the appropriate remedy would be to remand it back down to the circuit court to reassess or to allow for the filing of a successive motion with regards to that. That's really kind of how we see things at this point, because his entire application was focused on Beck, on the Beck decision.
Okay. Thank you. Anything in closing? Anything you want to add?
Just that I don't necessarily disagree with Mr. Babcock. The Beck issue obviously has never been fully fleshed out in the briefing in this case. And so depending on what happens in People versus Moughton, I think either remand for resentencing or remand for the actual 6,500 proceedings in trial court would be appropriate.
You can agree with them wholeheartedly too, if you want. That's fine.
It's hard for me to do.
I know. I understand. I understand.
That's honesty right there.
I know. I like it. Thank you, counsel. That case will be submitted. That concludes our 10 o'clock panel, and we are now turning to the 11 o'clock. With that, we've been on the bench now for a little over 2 hours. We're going to take a brief break and adjourn for a few moments, and then we'll return and start with the 11 o'clock.
Court of Appeals for the State of Michigan now in session. Be seated.
Thank you all for your patience. We will now move on with our 11 o'clock panel at the 12:21 mark. Moving to item number 27, case number 368-823, the Jane Scherzer Sizzle Trust v. Robert Bennett. Counsel, please state your names for the record, and I note that we have one counsel made a motion and approved and is endorsed for remote oral argument.
Good afternoon, Your Honors. Kevin Gentry on behalf of plaintiff appellants.
Thank you.
Good afternoon, Your Honors. Nick Loljuri on behalf of appellees Robert and Lori Bennett.
Thank you. Counsel, you may proceed.
Thank you, Your Honors. Well, I won't argue credibility because I never do that, and Your Honors don't care about it. I will tell you there's both a factual and a legal error here. The legal error, or I'm sorry, the factual error happens, as is often happens, when a trial court finds something that nobody argued and nobody testified to. And that's what happened here. The trial court, much to the surprise of everybody, decided that the driveway was a boundary line. The trial court based that finding, and this is where the legal error comes in, the first half of it, on a 1954 deed. The problem with the 1954 deed is it's called a chain of title. That division, that easement that's granted, and it is an easement, we'll talk about that in a minute, it was from 1907 deed, before the property was split. It couldn't have been a boundary because it was before the property was split. And it talked about the northeast edge and a marsh, totally separate from what we're talking about here.
Let's assume let's say we agree that that was a clear legal error. The trial court made an error regarding the deeds and what it showed and all of those things. How do we get to a point where we're able to say, okay, the property line isn't what both parties have gotten the God, I blanked on this again today. The property, the survey, the surveys, that it isn't the survey, it's actually the ash tree or the edge of the walk or whatever. How do we get to that point?
The biggest way we get to that point, Your Honors, is that we look at the fact that the survey packet defendants took with notice said all over the place that there were encroachments. It said that. They took it with notice. They didn't read it. They testified. One's a civil engineer and didn't read it. Okay. But it says there were encroachments. They took with knowledge of encroachments. And these encroachments, Mr. Ron Gross testified to them and was very clear on the fact that they were encroachments. Pretty much everybody was clear they were on encroachments. If you want to move the property line to somewhere other than the driveway, this court could do that, but I'm not sure this court's really into appellate fact finding. This case probably buys a remand to figure out where the driveway is, or I'm sorry, where the property line is, because we know it's not the driveway. It can't be the driveway on this record. It can't be the driveway on this. And you know what? If the trial court was right about the deed, it's still wrong, because the deed was for permission. Under Quinn and Cardone Lotti, that is an easement. You can't have an easement and have acquiescence for the easement. And even if there is an easement for the driveway, that covers use of the driveway. It doesn't move the boundary line away from the garage and away from the property. The trial court here tried to pull a King Solomon and split the baby. Unfortunately, got out the knife and cut the wrong thing. And we really need to see a remand on this to clean up this mess. I think this court could probably find from this record where the property line is. Perhaps a remand is in order because this court doesn't like to do first in fact finding, and I perfectly understand that. But one way or another, what we know is that the trial court got this wrong.
Anything else you want to add?
Thank you, Your Honors. I'll reserve time for rebuttal.
Any questions? No. Judge Moonstra, no questions. Counsel? Oh, you're on mute, sir.
That's probably for the best, Your Honor.
Terrific argument.
Is it permissible for me to share screen, to share a photograph that was an exhibit? It's in my brief. If you guys have my brief in front of me, but I was going to use the cursor just to demonstrate something.
Discretion. Yeah, I'll exercise my discretion, and if you can do it quickly, sure.
Yeah, I will. I think I just need permission to do it. I'll do it. It'll be really quick, I promise. Famous last words, right? It says sharing is not turned on.
Okay, and let's just proceed, and you refer to us because I can't do it.
Okay.
Why don't you just refer to us?
Sure. On page 2 of my brief, there's a photograph. There's a color version of it. Here, let's back up a second, because I don't agree with brother counsel as to what the deed show. But regardless of that, let's even assume he's right. I don't think it matters. Because what the trial court did in this matter, and it was interesting that the appellants at that time resisted the court taking a view. They went there, took a view. We had a 2-day trial. There were numerous exhibits with deeds and photographs, and these same arguments were made. And the court, and there was testimony, and there is a shared driveway between these two properties. And that court found that it's been there since 1907. And nobody testified any differently that they've been using this driveway for decades. We know that in the 1990s, the Bennett's predecessor in interest, Baumgrass, paved this driveway, and the former owner of the Pellets property said, I don't care if you pave it as long as you don't put a McDonald's there. He's kind of a funny guy. So if you look at that photograph,
Counsel, how does that equate to an agreement that the driveway or the middle of the driveway is the boundary line between the parcels?
you know, that's a good question. And that's why I wanted to share this, because all the testimony at trial and all the exhibits at trial was that the area that I would call the right of this photograph, that's my client's property, all that area was always treated as the property line for decades. And that's what the court found. The court went out there, heard the testimony, saw all the photographs, saw the videos. It took everything into account, reviewed the deeds. They made the same arguments. And the court said, hey, this has been treated. Remember, we're dealing with the doctrine of acquiescence, that this has been treated as the boundary line for decades now. And the court looks at the totality of the circumstances. One of the things that they bring up time and time again is this closing package. First of all, when they say one of my clients is a civil engineer, she had nothing to do with this closing. The parties were married after my client bought it, and then she was added by quitclaim deed, so she wasn't part of that closing. But one of their exhibits, and the court specifically references it, was plaintiff's exhibit 3, was there was an affidavit in lieu of survey done by my client's predecessor in interest, where they said there's been nothing put here for 27 years. And the court, in its very, very detailed opinion, which is a 15-page single-space opinion, goes through all the evidence and meets the requirements under the law for the doctrine of acquiescence. That's why I really wanted to show that photo, because I think this is a case where, quite frankly, I got involved after the motions for summary disposition. I was trial counsel, but I think what really, I think was really important in every real estate case, I think it's important that you actually walk the land, that you actually see it, not just this photo, that photo. The court did that, heard all the testimony, reviewed all the deeds, which I disagree. They say what he says they say, but I don't think it matters. And after reviewing everything, seeing it with its own eyes, seeing the photographs, determined that this has been treated as the boundary line for a long time, and really says this case is very similar to that Sackett versus Ateo case, which is 217 Mishap 676. I want to make sure I get that right. At least I can get the citation right. So the trial court got it right after a 2-day trial, after reviewing everything. It's too bad, but I would draw your attention to what was.
Most counsel wasn't, I mean, my read of the evidence was that it really focused on the shed and the ash tree that had been replaced, as opposed to real discussion about, the driveway or the center line or otherwise. It was, it all referenced to the ash tree and, the walk next to the shed.
Yeah, let me answer that. So that was Baumgrass's testimony, where I think it was his mother said that there was an ash tree that's no longer there. But what Baumgrass also testified to is that the area in dispute that we're talking about was always his property until the appellate came by and said it wasn't. And then we have this issue with the lease that anybody can terminate within 30 days. But we have to look at the whole record here, not just portions of it. And the whole record was very clear that this shared driveway has been used to access this property since 1907. There was no dispute as to that. They want to say that there's some other drive somewhere else that was brought up. The court rejected that. The court looked at the totality of the circumstances, listened to all the testimony, viewed the site, and determined that this property line had been acquiesced to for decades. And they found it by clear, convincing evidence. In page 10, And they go, the court writes, looking at plaintiff's exhibit 21 and 3, their own exhibits, the defendants say, and those exhibits being in line with the testimony presented during the trial, the court finds clear and unequivocal evidence that the midpoint of the shared driveway has been treated as the true boundary line between the parcels for more than 15 years. The court makes credibility determinations. There was conflicting testimony as to what happened in the past. And after evaluating all that, the court got it right.
So counsel, that driveway, the picture that you show on page 2 of your brief shows the very front part of the driveway, correct?
No, the driveway, Your Honor, this is where the driveway terminates at my client's property. So the driveway goes way farther back than that.
Well, that's exactly my point. If you look at the diagram, that driveway meanders all the way through the property. And if the midpoint of the driveway is the boundary line, you're essentially taking half of that parcel.
No, you're not, because you're talking about the parcel to the left. You're not taking half that parcel. That parcel's much larger than that. You're only taking that portion. If we're looking at the same photograph, if you're looking down at that photograph, you can see the garage to the right. What we're taking is this quarter of the garage. We're taking that walk. You can't see where I'm pointing, I'm sorry. And then it curves, and you're taking this area of trees right here.
But the driveway continues. So doesn't the property line continue with the driveway all the way down the driveway to the?
No, because my client's property ends before the driveway ends.
Do you understand?
No.
Okay. Counsel, would you agree that the relevant time period is when Baumgross came in possession of the property? In terms
No,
of
it extends beyond that. But even if that were that, there's an affidavit in Lewis survey where he says nothing's happened for 27 years. But this has been, as the court correctly found, the shared driveway since 1907.
Yeah. Any other questions? Any questions?
No.
Mr. Gentry?
Judge Boonstra, you just said why my clients are here. Because you just said why my clients are here. They lost half their property. They got a line that does this and cut off a massive chunk of their property that nobody testified was even in play here. I give counsel credit for gymnastics because that wasn't the closing argument he made. He's taking the trial court and running with it. And the problem is that trial court line runs halfway through my client's property, shaving off tons of stuff that wasn't even in dispute. There may be an ash tree here. There may be something there, but it's not, and this is his exhibit 2, that's not an easement. If there's an easement, as the trial court said, if there's an easement, as he said, that's a piece of garage built on an easement. An easement is permission to use. It never becomes acquiescence. The trial court here got this wrong and did an apples and oranges thing that makes it a little hard to untangle. But the reality is Judge Boons was right. My clients went there trying to deal with a few feet of their property and lost half of it. That's an error. Thank you, Your Honors.
Thank you, counsel. No questions?
Thank you very much.
Thank you, counsel. That
Take
case
care.
will be submitted. And that was case, just so the record's clear, it's 2 items at number 27, consolidated cases, case number 368-823 and 368-824.
I'm going to log off with the court's permission.
Yes, you may log
Take
off.
care.
Thank you.
Take care. Bye.
Calling item number 28, case number 369-719, Allen v. Bogan. Counsel, you may approach.
Good afternoon, Your Honors.
Good afternoon.
Patrick Chatterton on behalf of plaintiff appellee Zach Zegri. Alan, you can see on me. I expect the sister counsel here today.
Yeah.
Received no notification that she wasn't going to be.
Yeah.
Lovely drive here. However, it could have been avoided. And I know.
Yeah. Do we, did anybody check in? Nobody's checked in?
Give her a call?
No, I didn't. No, she's not easy to communicate with.
Okay, well, there you go.
Okay, well, you made the trip. Is there anything you want to emphasize or
Well, I think it's important.
make the points?
I think it's important to emphasize and make the point that this court's well aware of. It's well established. Chief judges such as Judge David Newblatt of the Genesee County Circuit Court made the decision to assign this case or leave this case with the domestic docket that Judge Thiele initially had, then Judge Christensen had, and then Judge Hannibal was appointed to the position that in the family court Judge Christensen held. He matriculated, I'll say, to the general civil criminal docket. So I think it's disingenuous to suggest that the court doesn't have the power to do that. Sister counsel had every opportunity to seek relief from this court or even the chief judge to reconsider his reassignment and never did that. So I think it's a moot point. I think it's a wild goose chase to suggest that he didn't have that power and didn't do the right thing. This court's familiar with cases that come before you where a judge will make the decisions in the case based completely on the record for a judge who's absent. It's happened in Genesee County several times when Judge Beagle was on the bench. So I think it's disingenuous to make that argument that it shouldn't happen, that it should have stayed with Judge Christensen as opposed to Judge Hannibal. The other arguments made by sister counsel in her brief, once again, I believe are disingenuous, not supported in fact or law, and her displeasure and defendant appellant's displeasure with the verdict of a jury in a case that, quite frankly, I doubt any of the three of you or your colleagues or any of my colleagues in the past have had a bifurcated divorce and tort trial case. I wasn't aware of anything like that happening prior to looking at a bar article, State Bar Journal, I think from the 80s
This was
perhaps.
the first for me.
Yeah, it was for me too. It was gratifying to have the jury find my client, I won't say not guilty, but certainly not responsible for the heinous acts that he was accused of. This will go down in my book of stories someday when I retire. I'm 35, almost 35 years into it, but this certainly is one to write a story about. And the journey we've taken from 2018 to 2026, I believe the court will make the appropriate decisions in relation to the appeal, and that you will affirm Judge Hannibal and the very credible job that he did in taking over a case that had been through two previous judges, a bench trial, which clearly Judge Hannibal reviewed the trial. We have video just like all the courts do now. I think perhaps because of a couple of the judges we had in Genesee County back at the turn of the century. So everything is there. Judge Hannibal reviewed the entire record. He had the exhibits from the bench trial on the divorce, we'll say, property and assets. And we believe he made a well-found decision. He determined that the parties should receive equally from the marital estate. I think it's important for the court to note the defendant appellant leveraged this home during the litigation. So the home was paid off. The marital home was paid off in 2017. And then during the pendency of the case, she leveraged that home and put a $40,000 mortgage on it with no notice to anyone. And I believe Judge Christensen expressed his displeasure for that happening because these parties were co-owners. We have standing guidelines in Genesee County where you're prohibited from doing things like that. And that clearly were violated. We're simply asking the court to do what's right. We're simply asking you to affirm Judge Hannibal's rulings, to deny the appeal that's been filed by sister counsel. And once again, I don't do a lot of appellate work. I think 15, 20 cases in 35 years. But the lack of case law citations, I mean, the utter conjecture of the arguments, it's like a house built on sand. It can't be sustained. It collapses with very little effort. And we suggest to you that that is what the defendant appellant's position or her positions are. And you should affirm Judge Hannibal. You should deny the appeal, and a rightful conclusion to this case is warranted.
Thank you, counsel. Any questions? No questions. Thank you, counsel. Appreciate the time.
May I have an excuse from the three of you for Judge Karras in Midland County Family Court? I have a 1:30 there that I don't think I'm going to make.
Oh.
You want a note? You want us to write you a note?
I'll tell them that the Honorable Judge Boonstra, Trebelcock, and
Yeah.
Letitia.
Letica.
Letica.
Thank you
Yep.
very much.
You got it. Thank you, counsel.
Have a great day.
Yeah, you too.
Well, what a beautiful building.
Don't get a speeding ticket.
Thank you. Yeah.
I've never been in here before.
Oh, there you go. Hopefully you don't have to visit us again.
That Court of Appeals case was so long ago that the courtroom was in a building a stone's throw from the Capitol. So it's.
I know where that was.
The stakeout.
Yes, I know.
Have a great day.
I know
Thank
the
you.
building that you're talking
Yeah.
about. I remember the courtroom being there. Yep.
Thank you. Have a great day. That case will be submitted. Now calling item number 29, case number 375-230, J. Jefferson Company LLC v. City of Jackson. Counsel, please approach and put your appearances on the record.
Good morning, Tom Cedos from Hush Blackwell on behalf of the appellant, Jay Jeffers.
Good afternoon, Your Honors. Matthew Haggerty on behalf of the appellee, City of Jackson.
Thank you. You may proceed.
I understand that the court has read all the briefing, and so I'm going to try and limit this. I would like to save a few minutes for rebuttal if that's appropriate, but really there's two kind of issues in this case. There's the procedural issue related to our amended complaint. So Jay Jeffers, we filed a lawsuit almost immediately after we learned that this property, the Hayes Hotel, was being sold to another developer. And we filed a motion for TRO with that. After we end up having a TRO hearing, that TRO is denied, a preliminary injunction hearing, I'm sorry. That preliminary injunction was denied. At that hearing, the city had served a motion for summary disposition on us. We had, in response to that, we had filed an amended complaint, adding several claims, several causes of action, adding 3 new parties, another plaintiff and 2 other defendants. And the amended complaint, for all intents and purposes, wasn't considered. There's arguments about whether it was futile or not, but 2 of the claims are actually unrelated to the termination provisions, the 2 breach of contract claims that were added against the city. In addition to that, there's a question on the contract interpretation, automatic termination. So the city relies on the Silver Stallion case, which had language that said if this agreement doesn't, if the closing does not occur, the agreement automatically terminates. In our contract, that language is noticeably absent. There's actually some remedy asymmetry involved here, where Section 18 allows the seller, it does not have any, it does not allow the seller to actually terminate. It has no automatic termination rights. Section 18 for if the buyer defaults, city keeps earnest money deposit only. If the seller defaults, the buyer gets full reimbursement or specific performance. They negotiated every consequence in this contract. And so the trial court erred by reading in a termination provision that doesn't exist. And then beyond that, what actually caused the misclosing remains a dispute. This is a case with no discovery has taken place. In the amended complaint, we lay this out clearly that the city missed a revolving loan fund deadline, causing funding to be delayed. So my client came up with some new alternatives, including low-income housing tax credits. At the very end of this, we find out that that's something that they object to. And so the parties continue negotiating well past the December date up into February. And then out of nowhere, they find out they sold it to another developer, which leads us here today.
Okay. Any questions?
Nope.
No questions. Thank you, counsel. You have ample time for rebuttal.
Thank you, Your Honors. This is an expiration case, not a default case. I think as the record and briefing makes clear, this is a straightforward contract expiration, Michigan statute of frauds, and municipal authority case on those 3 fronts.
But counsel, in the first amended complaint, there were new counts added, and I know it was discussed at the oral argument, but the court never really found anything, the amendment futile or anything like that. But some of those counts alleged breaches by your client before the contract would have terminated or expired, right? Essentially alleging you breached before they did or before it terminated. So why doesn't that survive for later consideration?
It doesn't survive, Your Honor, for one critical reason. The default provisions, as alleged, would have required the city to get notice of the default. And there is zero evidence in the record that the appellant ever gave the city any notice that there was a situation by which the city had not done anything pursuant to the contract. The contract on December 31st, 2024 expired. And after that time, there was no curability. The contract was over with. And
Did
so
they extend it by, I'm sorry to cut you off, but did they extend it by conduct? Could they extend it by conduct? Because they continued to negotiate, right?
they couldn't have, Your Honor, Judge Trebilcock, and this is the reason. That they knew, the appellants knew full well that the contract had expired because they proposed after 12/31 of 2024 to execute a new contract altogether. Before that time, there'd been a first and second amendment that both had to go to the Jackson City Council for approval by the full council. So they knew when the contract was executed in 2022 that there was going to be a firm deadline extended to 2023, again to 2024. And there is in the record two separate correspondence that indicate very clearly to the appellants that the contract is going to expire. It's on the cusp of expiring, and they sat in their hands.
But in both of those prior instances, am I correct in the understanding of the record that the extension of the original expiration date wasn't completed until after the expiration date, correct?
Say that again, Your Honor.
So I'm just making this up if it expired December 31 of 2022, the approval of the extension beyond December 31, 2022 didn't occur until after that date.
No, in each of those instances.
Did they do it prior to reaching the expiration date?
They did.
Okay.
The council, the city council approved them before they were going to expire. And that was the impetus for the correspondence saying, actually inviting the appellants to come to the December, I believe, 10th city council meeting, the last council meeting of that calendar year, knowing full well at the end of that month, when the clock struck midnight on 12/31 of 2024, the contract had expired. And again, they knew it because they'd gone through this process previously with one extension already. And then in February, 2 months after the contract expired, they had proposed executing an entirely new purchase and sale agreement.
So just to get into following up on Judge Boonstra's point, you concede, would you concede that the trial court did not find or make any findings or rulings on futility on the amended complaint?
I believe the record, the record is short on that, Your Honor, but I would say that with regard to futility, the amended complaint was obviously filed and accepted. The two specific counts that were filed against the city were, again, a breach of contract and equitable estoppel theory, the same exact theories that were filed in the original complaint. So
No, I don't think so. These alleged that your client didn't perform its obligations under the contract prior to closing, before any expiration. Right? That I don't think was alleged in the first complaint.
there were allegations that the city disagrees that they didn't honor their contractual obligations, particularly with regard to ordering the title policy and some of the other pro forma matters that would get the parties to the closing table. But there was nothing in the record that indicated that the city breached the contract beforehand, nor after expiration was there any remedy at that point, because once the contract had expired, and again, they didn't ever provide notice under that Section 18 of the agreement to say, city, you have 10 days to cure, I'm giving you notice of the default. The
Trial
notice
court
of
didn't
default.
rule on any of that, did it?
I'm sorry?
Trial court didn't rule on any of that, did it? It simply said it expired.
The trial court did say it expired, and on the basis of the fact that the 12/31/2024 deadline had run, it was irrelevant because there was no contract to remedy. Once the expiration date hit, the contract terminated. There was no cure. There was no ability to go back.
Under the contract, let's say it did expire, couldn't there be breaches that give rise to claims that occur after the expiration of the contract? You know, the typical breach of contract statute of limitations is 6 years.
Presumably there could, had the contract's provisions regarding those breaches been followed. Here they were not, nor does the city ever admit or state throughout the record that there was any indication that there was any such breach.
Any other questions? Any questions? What additional points do you want us to consider?
So again, with regard to termination, and I cited the Tash case, an unpublished opinion to this court, you don't need that talismanic language about termination in the agreement. In that court, in that decision, the court expressly rejected the argument that it mattered whether the contract explicitly stated it would terminate upon the passing of the closing date. The expiration of the closing date is itself the agreement's termination. So otherwise, you're going to create an unlimited option where the contract never had an end date. And the city, through 2 extensions, waited and waited and waited. And then finally, in subsequent correspondence after the contract expired, the appellant says, well, maybe we can close in June of 2025. And the city had millions of dollars of grant funding at issue that it was potentially going to lose if it did not get this property sold. And the other important point is this was not a $25 million purchase. This was a hotel built in 1929, 100,000 square feet. The city was selling this to find a capable developer for $25,000. And so this was not moving heaven and earth to get to the closing table to bring the funds to close. And that was expressly pointed out by the trial court, is they never tendered performance. So in terms of breaching, and to Judge Boonstra's question, they failed to tender performance, which is the ultimate issue at hand in terms of getting to the closing table. You have to provide the funds in order to acquire the property. They never did so. And with regard, again, with regard to the amended complaint, the same 2 causes of action, the breach of contract and equitable estoppel claims are asserted. An amendment by right, of course, the First Amendment complaint was allowed to be filed, but that affects the procedure and not the substance. You can amend by right, but not to assert a legally insufficient claim. So to your question about any breach during the terms of the agreement, the city got no notice of any such breach. There was no provision that followed notice that followed the provisions of the contract. It simply expired, and then after the fact, again, based upon appellant's own documentary evidence, they say, we want to execute a new purchase and sale agreement after that it expired.
Don't we, even if we were to agree with you, isn't that a decision that the trial court needs to make in the first instance on the merits of whether the amendment is futile or?
I think they did so. Obviously, the amended complaint. So again, as brother counsel indicated, this first came before the court on an injunction motion, which the trial court denied and indicated that the contract expired. A C8 motion was subsequently filed, and the court heard the oral argument, heard the evidence, obviously had receipt of the First Amendment complaint, because prior to the hearing of argument on that, brother counsel had filed the First Amendment complaint between the time of the denial of the injunction motion and then 3 weeks later when the motion for summary disposition was heard.
And clearly it was addressed during the oral argument. The court was aware of it, but it never addressed it. It never said, I find it futile because.
You're correct, Judge Boonstra, in that the trial court didn't specifically articulate the rationale why, other than to say they found that the amendment would be futile. And that was part of the stipulated order that was entered.
Counsel, you have time for rebuttal. Thank you.
Thank you.
Couple of items I just want to briefly address. The trial court, as you guys noted, never ruled on whether the amended complaint, oh, go ahead.
See, it happened again. We're not you guys. You just said you guys, referring to us. So we're either the bench, your honors, but not you guys, clearly, not a guy.
My apologies.
All right, go ahead.
So the trial court never actually addressed the issue of whether a notice was sent. The reason the amended complaint was filed when it was filed is because on the date that the original lawsuit was sent, a notice of breach and demand to cure was actually provided to the city. And so that's why the amendment took place after, because we had to meet that condition precedent to actually file suit. Obviously, that demand was rejected. There was nothing was cured. So that was never addressed. The other item I wanted to bring up is actually the amendments. So the amendments, both amendments were executed after the closing date was, had passed. So I know
So he was wrong about that.
yeah, the one was in April, was April 3rd, that was the second amendment was executed. That was in 2024. And the other one was in January, I believe, of 2023. And then the last I want to just, in the actual contract language, in section 18.3, in any case where the purchaser elects to or exercises its right to terminate this agreement, including without limitation, section 5.1, section 5.3, section 6.2, 7.3, 7.9, we had filed claims in the amended complaint under 7.3 and 7.9. It says the seller elects to exercise its right to terminate this agreement under section 8. It has the right to carry on all remedies under this agreement. And so those are remedies, actually, there's remedy asymmetry, as I mentioned earlier. It allows them to go and obtain the $1.8 million in costs that they had spent the last 2 years for. The reason the city had funding, the reason the city had grants was because of the work my clients had done. And so if there's no other questions, that's all I wanted to.
And is he right about it being futile for the reason that you didn't give them notice of the breach?
No. Oh, sorry. My apologies. I thought I addressed that. No, we had provided notice of breach and to cure in
All right.
February.
Was just asking if he was
Yeah.
correct about that. So the answer is no. Okay.
Any further questions?
Thank you.
Thank you.
Thank you, Your Honors.
Thank you, counsel. And last but not least, item number 30. People v. Lewis Jr. Smith, case number 369-597. Mr. Machasik, you may approach and you have 10 minutes for oral argument.
Thank you, Your Honor, and may it please this honorable court, Ryan Machasik on behalf of Mr. Smith. Your Honor, I'm not going to go through all of the arguments.
Well, the prosecutor is conceding error on issue 1, right?
Yes, Miss Armstrong is now my favorite prosecutor.
Oh.
But we do have I would point that we have a small dispute about what should happen because of that.
Okay.
I'm asking for a remand for resentencing.
You are.
And Ms. Armstrong, though she is not here, I will say is indicating that it does not need to be remanded. The reason that this should be remanded for resentencing is if the court vacates a criminal sexual conduct 3rd degree for which my client received a
10-point score on PRV 7.
Correct, Your Honor. That is certainly inaccurate information under which the trial court was operating.
Okay,
The trial
so-
court, I'm sorry.
Okay, so PRV 7 says, or you have a subsequent conviction after the commission of the offense that you're being sentenced for. And in the prosecutor's sentencing memo, it says he has a subsequent conviction for a felony. And in response, trial counsel said, I agree, 10 points should be scored for PRV 7. Never came up at sentencing. Does that not fit under PRV 7 when his PSIR shows that he has a subsequent felony conviction? The statute's written, the scoring is written alternatively, right? Concurrent conviction. You're 100% correct. We put a big X on that, but he's got a subsequent conviction that would have allowed the court to score 10 points. Why
And-
should he be resentenced?
And it's for this reason, because regardless of the point tally, and I take, I
Okay.
take your honor's point.
You're saying it's an accurate information that he had a concurrent conviction?
Correct, because he at that point doesn't, and the court, and part of the reason that I would point to is this. The sentencing transcript, beginning of around page, I think 43, 44. The trial court talks and discusses how the other convictions, right, weigh on the court's fashioning of the sentence. And the sentence is within guidelines.
Mhm.
Guidelines are, of course, not mandatory, but it is within guidelines, but goes about 3 years from the bottom of the sentence imposed above that mandatory minimum of 25 years. And so because the trial court, this is something that the trial court is discussing and relying on in fashioning its sentence, I think it's only fair that it be sent back to the trial court, which, I mean, the trial court may say, I'm going to impose the same sentence in any event. But this is certainly, the fact that there was this other conviction, I think, is something that the court weighed at this point, we know, inaccurately in fashioning its sentence. And so that's the basis, is regardless of the point argument, it should go back. But I take your honor's point.
Okay.
Any other questions on that issue one? No.
I'll continue. I know there are a few other issues that you raised, so if you want to address those.
Thank you, Your Honor. And so briefly on issue 2, which is the statement introduced through the officer regarding what the victim had told him when he responded. The trial court cut off cross-examination and it was in the portion of cross-examination that was voir dire regarding the excited utterance exception. I'm not arguing that this did not fit within the excited utterance exception. And so there was the foundational testimony that the alleged victim was visibly shaken, crying, and exercised when he approached her, and she made this statement that she had been sexually assaulted. Where the court cut off trial counsel, however, was he is trying to get to what the timing was between when this occurred, when the call came in, and when this statement is made. And the reason that it's important is not just because it's foundational to the excited utterance exception, but because in addition to it being something that the court should have weighed, and so the court didn't do a full analysis on excited utterance, the court should have weighed the timing as part of its analysis in admitting this. But above and beyond that, this is something that the jury should have heard. The jury should have heard that there was a time lapse between when the startling event occurs and when this statement is made, because it's something that the jury can weigh in determining the credibility that they give to it, just generally the weight that they are going to give to that statement. I'm not going to belabor the point, the arguments made in the brief, but that's the crux of it. But I'm also happy to answer any questions that the panel may have.
Any further questions, Judge Letico? Thank you very much for the briefing and argument this morning and your patience waiting through our call. That case is submitted, and that concludes our panel number 4 Lansing session for April of 2026. Thank you.
Have a good day, Your Honors.